Everyone. This is a code enforcement hearing for the city of North Miami. Today is August 3rd, 2023. I'm Jose Smith, Special Magistrate for the city of North Miami. The Special Magistrate is empowered under the Florida statutes and the North Miami Code to hold code violation hearings. The purpose of these hearings is to determine if a code violation exists at your property as observed and cited by a code enforcement officer of the city. If the city is not able to prove its case, then I will dismiss the case and you may leave. These proceedings are being recorded, so all persons who are speaking should do so one at a time to ensure that all testimony is clearly audible on the recording. If English is not your primary language, then please inform me when I call your case. We have translators and interpreters who will assist you during these proceedings. When your case is called, the property owner, agent for the property owner, and any witness that you may have should announce yourselves. And when asked, please speak directly into the microphone and say aloud your name, your business, mailing address, and your relationship to the property. If you are not the property owner or an attorney representing the property owner, then you must present a notarized power of attorney in order to testify in these proceedings on behalf of the owner. For new cases, you will be asked for the record if you're aware and understand the violation that is being heard today, and do you understand what is required to resolve the violation. The city will present its case first, and then the property owner or violator will be given an opportunity to testify on their own behalf, to bring forward witnesses, to testify, to present evidence and photographs, and to cross-examine the city's witnesses. Following the case presentation, I will issue findings of fact on the case. If I find that a violation of city code exists or existed on your property, then depending upon the case type, I will set an abatement date for the violations to be corrected. Or for repeat violations, I will impose a daily fine amount. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation, and a daily fine amount that I may impose at a future hearing should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement action at this time, I will table or continue the case until another hearing in the future. If you do not agree with my findings of fact, then you may appeal my administrative order on the case to the circuit court. An appeal must be filed within 30 days of the date of the execution of my administrative order to be appealed. In accordance with Florida law, if a person decides to appeal any decision made by the special magistrate with respect to any matter considered at these proceedings, then the person will need a verbatim transcript of the proceedings. This record includes the testimony and evidence upon which the appeal is to be based. Cost of obtaining the verbatim transcript shall be the sole responsibility of the appellant. And it is recommended that persons who plan to appeal their case should provide their own court reporter at these proceedings. Pursuant to city codes, if the city of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment amount is $100 per case. Once the city reports an order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative fees to record and release the lien. At this time, I will turn it over to staff for the purpose of swearing in the witnesses and also for the Pledge of Allegiance. Madam Clerk.
Magistrate will have the officer do the Pledge of Allegiance and swear in the officer once afterwards. But
Okay,
everyone, please enable your camera and audio.
You're welcome.
Okay, are we ready?
Yes.
Okay. I pledge allegiance
allegiance
to the
The
flag
flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Now for the swearing in. Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do.
I do.
Thank you.
I see that the interpreters have also been sworn in.
They'll be sworn in now. Interpreters.
Okay, raise your right hand. Do you solemnly swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skill, and ability? Say, I do.
I do.
I do.
Thank you.
Okay, any additions, alterations, amendments to the agenda?
Yes, there is, Magistrate.
Okay.
So as far as for the amendments and deletions from today's agenda is item number 1 through 4, which is 1180 Northeast LLC. Case number for item number 1, CEFAW 2022-00071. This case was postponed. Item number 2, case number CEGMP 2022-00114. Postpone. Item number 3, case number CEODS 2022-00172. Postpone. And item number 4, case number CEZPU 2022-00117. Postpone. And as well as item number 59, San Marino 730 LLC, case number MHVIO 2022-00482, postpone. And as far as for the complied cases from today's agenda, we have item number 36. 1 second. Jacob Prasnik Trust, case number CEZPU 2023-00173, complied. And item number 44 and 45, which is Noel Apartments LLC, case number for item number 44, CEBPR 2022-00652, complied. And item number 45, case number MHVIO 2022-00302, complied.
Let me ask you about item 36. By complying, you mean that they eliminated the water sports features of the property and they agreed that they couldn't do that anymore, correct?
That is correct.
That is correct.
Okay. All right. Let's move on. Is the city ready to present its first case?
Yes, the first case I'm going to be calling in today is item number 33. I believe, give me 1 second, which is Causeway. Case number for item number 33 is CEMDU 2023-00016. The officer is Bradley Daniels, and I'm going to allow the attendees into the hearing right now. Give me 1 second.
Yeah, just for the record, the legal name of the entity in question is Causeway Apartments LLC.
Yes. All right, I've given access to George Savage, Angie Bravo, and Victoria Barrientos. Sorry if I'm pronouncing your name wrong.
What was the second name?
Angie Bravo,
And the first name, George what?
Savage.
Okay, Savage. Any of the three of them an attorney?
I believe George Savage is.
Okay,
Just
Okay,
waiting on
is it-
Angie Bravo.
how do you spell the first name?
For which one?
For Bravo.
George, George. Angie, I'm allowing you into the panelists. Please accept the invitation. All right, so we have all three attendees in now.
Okay. Is the code officer ready to proceed?
Brantley, are you ready to proceed? I'm going to go ahead and share my screen as he's presenting.
Go ahead and step in for Mr. Daniels. He's having a little bit of a discrepancy right now with his audio. So today we're going to hear the case as relates to the property at 690 Northeast 123rd Street. This case
Identify yourself first, Mr. Perez.
You're absolutely right. My apologies. Jose Perez, the manager for the Neighborhood Services Department. Today, we're going to be looking at the property at 690 Northeast 123rd Street. This case was opened by Officer Brantley Daniel, and this violation as it relates to mold in Unit 103, which was indicated by a mold report the tenant provided to the property, to the Officer Daniels. At this point in time, the property owner was given a time frame to rectify and allow for mold remediation, and they provided a remediation report that contradicts directly with that of the tenants. So at this point in time, there's two conflicting statements. These reports were taken back to back, basically, and the discretion is being held on the magistrate as to how to proceed, as the tenant is advising that there is no mold issue at the property. I'm sorry, the tenant is advising there is a mold issue at the property, and the property owner is advising there is no mold issue at the property. Two certified mold reports, both conflicting statements. No remediation has been done due to the fact that the second report advises there is no mold. So at the discretion of the magistrate, we are trying to seek how to proceed with this case.
Is the tenant going to testify?
Yes, Your Honor.
Okay. Mr. Perez, are you going to call the tenant as a witness?
Yes, Your Honor. We're going to go ahead and have Ms. Barrientos go ahead and speak into the record. Ms. Barrientos, if you could please enable your camera so that you could be on the record with your video camera as well.
And also, please raise your right hand. I'm going to swear you in.
Yes.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
Yes, I do.
Okay, Mr. Barrientos, you want to question the witness or you want me to?
You could take lead special magistrate.
Okay. Your first name, ma'am?
Victoria.
Are you the tenant of Unit 103?
Yes.
How long have you been a tenant?
Almost 12 years.
Who's the landlord?
Causeway Apartments.
Are you under a written lease?
Yes.
Okay. when did you first notice any mold in your unit?
We've been having problems since 2020. And I have a respiratory problems, and I went to the doctor, and the doctor tell me that I need to check my air conditioning. And I called her, and she did. She cleaned up the dogs and everything. But since that day in 2021, it happened again, and she cleaned up again for everybody. I think so. I don't exactly know. And then this year in January, I noticed my bathroom, because we have been leaking in the bathroom for years. And they come in, they took the ceiling, the part is leaking, and they put it another one. And I've been telling since January, we have leaking in the bathroom. You need to fix it. And she didn't do anything. And then again, I say, you have a leak in the bathroom. When I look in the ceiling, there was a hole. And the hole was coming like a green stuff. And I start asking everybody, why is this? And they told me, you have a mold. And I sent a letter to her. I said, listen, you need to fix this, because I think so we have a mold in the apartment. And finally, she sent in April to fix that hole. And they do the same. They came in, open it, and I said, don't close it till get this whatever is wet, dry. And I went to school. When I went back, already was closed. They came into the apartment. They spoke with my husband. My husband, I'm sorry, but he's really sick. He doesn't know what he knows that they're working in the apartment and let them in to do. When I came back, I said, why you close it? I want that you get dry. But it was done. And I say, Angie, we have mold. When I called the city told me that it's closed. They can do anything if I don't provide a report. And I pay for the report. They
Yeah,
came.
ma'am, I don't need you to give a speech. I just need you to answer my question.
Okay, that's what I
Okay.
find out.
All right,
When
so
they-
let me stop you there and ask you where was the and I assume it was a water leak. Where was the water leak coming from?
From the bathroom in second floor.
Okay, any leaks from the air conditioning system?
We've been having two times this year.
Okay, so you had leaks. You didn't feel well. You said you had some respiratory problems. Did you ever have respiratory problems before?
Never.
Okay, and did the doctor explain to you why you were having respiratory problems?
Because I'm start having chronic allergies and I start having chronic sinus. I never had it. And they told me that there's something in my apartment that is doing this.
Okay, did you call for an inspection by a remediation company?
Yes.
Mold assessment report. I believe the company, I don't know what the name of the company.
Mold specialist. Mold
Okay,
specialist.
who called for that report?
I did. I pay for.
Okay, who's Victor Lugo?
I don't know who's Victor Lugo.
Okay, did you review the report?
Yes, I did.
Okay, did you take a look at the pictures?
Yes, I did.
Okay, Mr. Perez, I assume that neither expert is going to be testifying at today's hearing. Is that correct?
That is correct, unless the property owner or the tenant did ask them to speak, but we do not have
Okay.
them registered.
If they don't speak, I will deem the reports to be hearsay, subject, of course, to certain hearsay rules, even though in special magistrate proceedings, hearsay is often allowed when it comes to the ultimate issue in the case, whether or not there's mold. I'm not going to let the report in to prove that. I may let the report in for other exceptions to the hearsay rule, but for purposes of determining whether or not there was mold in the apartment, unless the expert is present and subject to cross-examination, I'm not going to let that in.
Magistrate, give me 1 second. I see there's a Yang Lopez here in the attendee queue. I'm gonna allow him to speak. He's saying he's
Okay.
here to testify.
Okay, and that's spell the name again.
Jayne Lopez.
Jayne
Lopez.
Lopez. Okay. We'll get to him shortly. Ma'am, so you paid for the report, and
Yes,
are there photographs that are part of the report?
yes,
And are those photographs accurate? Did they depict the condition of your apartment at the time the photographs were taken?
yes. I was here. I was following them to do everything.
Okay. And I noticed there was a lab report with some certain numbers on it. And again, I'm not getting into the science of it or the expert's opinion unless they're here to testify, but I did see some photographs. And I'm gonna allow for purposes of this hearing the photographs that the company took of your apartment. By the way, Mr. Perez, did you or somebody in your staff visit the apartment to determine whether or not there was mold?
Yes, staff did visit the property. Myself and Director Raymond visited the property as well. However, none of us hold certifications in mold, so therefore we cannot testify to whether or not there is mold. I will say that the tenant did share several photographs with Officer Daniels and myself as it relates to the conditions of the property. But again, since we're not certified in mold, we cannot testify whether or not there was in fact mold at the property.
Okay, those photographs that were shown to you showed what?
It pretty much showed a hole in the ceiling of the property in the restroom with some black spalting in the restroom area. And there were some other photographs depicting the air duct vents. Those pictures were shown to me by the tenant's daughter, Jane Lopez, who is here on the screen as well.
Okay, is there anything else that you want to add to your presentation? And I'll ask you to comment on the other report that was submitted by the landlord. Have you had a chance to look at that report?
Yes, I reviewed both reports. As I mentioned at the beginning of my presentation, they're conflicting reports because one advises there is no mold and the other one does advise that there is mold. At this time, the city doesn't have the expertise to determine which report is or is not accurate. The city does not have the certifications at will to do their own testing either. So that's not something feasible for us. I will mention that based off research and due diligence from the city, we did determine that both companies are certified and both companies do hold certifications in mold remediation and mold identification. So whether or not any of these conditions are accurate on the report, that's at the determination of Special Magistrate Smith. We'll leave that determination to you.
Okay. Just for the record, as a private attorney, I handle many mold cases. I'm familiar with the issue. This is not my first rodeo. I've read both reports carefully. I understand mold, and so I approach this case as I would approach any other case. But I reviewed both reports. When was the last time you visited the apartment, Mr. Perez?
The apartment was visited previously on, I have the date here.
May.
Roughly May 22nd, if I'm not mistaken.
Okay. So the original report is dated June 7th. So you had already visited the apartment by June 7th?
Correct.
Have you had a chance to go back since the second report was issued?
I went back to see the report. Ms. Barrientos had the physical report in hand, and we went to go see it in person.
Okay. I assume that George Savage is here as an attorney representing the property owner. Is that correct?
That's correct, Special Magistrate Smith.
Okay, Mr. Savage, do you have any witnesses that you want to put on?
Yes, I have the property manager, Angie Bravo, who is on the Zoom. And before I put on the witness, I would like to make sure that Special Magistrate Smith is aware that the notice of violation is defective as a matter of law, as it identifies a property in Key Biscayne. So the underlying document that provides for this proceeding does not identify the property that is the subject of this particular hearing. So as a matter of law, Special Magistrate Smith, there is no basis by the city to conduct this hearing because the notice of violation, which is the basis, improperly identifies property in Key Biscayne.
All right, let's deal with that preliminary issue first. The city, okay, who's posting that?
I am magistrate.
Okay, so instead of Key Biscayne, it should have said Miami Beach.
It should have said the city of North Miami, magistrate.
Yeah, but I believe that the notice went out to the address that is listed on the property appraiser's site as 450 Olton Road, apartment 11-3. That's the mailing address of the owner, Causeway Apartments. And I believe that unless I'm very wrong, because I happen to live on Miami Beach, I believe that Olton Road is on Miami Beach and not Key Biscayne. So it appears that that may be an error. Is that correct?
If you're asking me, that is not an address on Miami Beach. That is an improper. It should be Alton Road in Miami Beach, but unfortunately, when the deed was created, it has Key Biscayne. But the more important issue is the violation references a property that's which is 450 Alton Road, Key Biscayne, Florida. It doesn't reference the North Miami property that's the subject of this hearing.
All right, but you're here, you were served, you accepted the process. You're challenging the service nonetheless.
I'm not challenging the service, I'm challenging the violation notice. If this was a court of law, this is a charge that lists a property that is not in the city of North Miami. And this is the document that gives the city the right to hold this hearing.
All right, Sadie, have you noticed this particular property as being deemed in violation of the code?
Yes, we have. And per Florida Statute 162, the requirement of having an actual address on the notice would fall under citations. This is a notice of violation, which has a different requirement statutorily, which does not require necessarily the address being on the notice itself. However, we did specify Mold in Unit 103, which is owned by Causeway Apartments LLC. Therefore, we did cover bases on specifically indicating Unit 103. Moreover, when the property owner was reached, Miss Angie, we did speak to her directly over the phone. Director Raymond went ahead and called her personally, and we did speak to her as it relates to the violation. So the property owner, the property management were well aware of the violation and where it was taking place.
All right, did you post on the property?
Absolutely, the property was
Yes.
posted and was sent via certified mail.
Okay, that's what's different about trying a case in circuit court and being before a special magistrate. In under Florida law, posting on the property is sufficient notice of service. So let's put the procedural issue aside and deal with the substance of the violation, which is an allegation that there's mold in the apartment to this day, according to the tenant. Mr. Savage, can you put on your first witness?
I'll call Angie Bravo
Okay,
and ask Ms. Bravo to give a brief background in response to, and by the way, Ms. Jane Lopez, who's on, she's not a tenant. She's not an expert. She's the daughter, we believe, of the tenant, but I don't believe that she is allowed to be on this hearing. She's not an expert, and I don't believe she filed to show up for today's hearing. So she shouldn't be allowed to be in the Zoom.
I don't know what individual you're talking about because I've got all the names.
Jane Lopez, your city clerk allowed her into the Zoom. And that was
Okay, it's a public meeting. So
Okay.
Yes.
anybody can watch, but I don't see any reason why, unless she's an expert, I don't see any reason why she would need to testify.
As
David?
George mentioned, she's the daughter of the tenant that's on currently.
Okay, so she's not gonna testify then.
She mentioned that she was. I'll just have to swear her in
Okay,
when she
well,
does.
when she does. At this point, I'm hearing from the property owner's attorney.
Okay. Angie, if you could please provide a background to Special Magistrate Smith in response to what the tenant stated about the mold or water leaks.
Angie, before you begin, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Proceed, Mr.
Okay.
Savage.
Angie, please go ahead and proceed with your background as to the status of the unit and with the tenant and the water leaks.
Okay, so since she mentioned that to me in 2020 that the air ducts and the air conditioning was not producing good quality air inside the unit, I went ahead and hired a professional company to come and do some duct work, put a UV light in the unit to try to help the air quality. We also clean the air conditionings every 3 years. The last time we did it was in 2019. And we did that air duct work on 2020 and then again on 2022 for every single apartment in the building. Now, she mentioned that she had a leak in the bathroom and we fixed it. We actually leave I hired a professional company, a plumber, to do the work. And we leave the bathroom ceiling open for 2 days in order to make sure that the leak did not come back. After that, we saw that no leak was coming down from the unit upstairs, and then we decided to close it down. So now every time that she has called me or my team, my maintenance team, to do any work in the apartment, we have doing so. Every time she complains that she has a leak or like the air quality inside the unit, if I cannot do it with my on-site maintenance, I will hire a company to do so.
Leave that picture on the screen because I'm gonna try to identify some of the issues in the case. Again, the report is not in as evidence, but I'll be quoting from some of the comments because I'm going to deem some of the comments to be admissions of a party and declarations against interest as I go through the report. But essentially, the areas that are designated in pink are the areas that were subject to inspection or remediation or corrections. Is that right?
Well, are you asking the witness or are you asking the?
Well, I'm asking the witness.
Well, the AC had a leak, but it was coming down from the bottom of it. Like we had the AC company to come and do the coil clean and everything that we had to do in order to stop the leak, and we did so every time she called us. We also replaced the AC filters for every single unit inside the apartment building every 2 months, sometimes every month, depending on how hot it's outside and how they use the air conditioning in order to prevent all these things. I'm about preventing maintenance, and that's what I do in my property. Now, every
Angie-
time she has called us for a leak in the AC, we have addressed the issue. Now, sometimes she doesn't let us in to change the AC filter, so we leave it with her. Are you gonna say something, George?
Yeah, I was gonna follow up. What is your understanding of the AC filters being changed by the tenant?
Well, so she sometimes doesn't let us in, but in the times that she does, we have encountered that the brand new AC filters are by the air handler not being put on, and the dirty one is inside. So that causes also the AC machine to double work and also causing these leaks. So I cannot obligate my tenants to let me in. So with the only way we have is to leave the AC filters with them. But every time she has any issue with the apartment, we have comply in a timely manner as well.
Angie, when you found out about this claim of mold, what did you do as the property manager for Causeway Apartments?
I actually hire a professional company to come and do the report to actually see if it was true, because if it is, well, you know, we have to take the steps to solve it.
Did you contact the city of North Miami that you had contacted and had engaged a professional mold inspection company to come to the unit?
This is the thing, the city, I believe is Jose Perez called me with the tenant. I was on the speaker with them and told me that the tenant had a report that said that that unit had some mold. And I told him that I will hire a company to do a report. That was 1 week before I got the notice of violation. He said that he will not enforce the notice of violation if I bring a report that says that there is no mold inside the unit. So I said to him, these reports usually take some days to get it done because they run samples and they have to send it to a lab in order to confirm what we're trying to do here. So he said, I'll give you a week. Say it was not enough time, but anyway, I tried to comply with it. And 1 day before the violation, no, at the same day, we got the actual violation posted on I'm sorry, not the violation posted, but the day I have to comply with everything, which is June 22nd, I was able to send my report to them, but I already had that violation in hand. They didn't give me time in order to do all these things myself.
Angie, did the property owner hire Air MD environmental consultants?
Yeah, we hired them. Mhm.
And did they provide you with a report?
Yes, they did.
And is that the same report that you provided to the city of North Miami?
Yes.
And is that report done after the report that was done by the tenant?
Yes, it was done, I believe, on June. We got the report back from them on June 22nd. It was done before a week before that.
Are you aware of any other testing that's been done by the city or the tenant after the report that was done by Air MD?
No.
And is it your understanding that the Causeway Apartments has taken all steps to evaluate the allegation that there was mold in unit 103?
Yeah.
If the city were to say that you need to do remediation of any portion, would Causeway Apartments do remediation?
Yes, of course.
At this point, does Causeway Apartments believe that there's any mold in unit 103 based on the report from Air MD?
No, there is no more.
I have no further questions, Magistrate Smith.
Okay, thank you. Good direct examination. I appreciate it. Let me just ask, by the way, does the city want to cross-examine the witness? Jose?
Not at this time.
Okay, let me ask some questions so that I'm clear as to the scope of the report and and as council stated, potential remediation efforts that may have to be done. First of all, let me ask you this. When the company came out in June, apparently June 20th, had work already begun to address some of the issues raised by the tenant?
We had fixed the AC leak, which was the only issue she pointed to us. The
Okay.
AC leak was fixed back in May. The only thing that we saw on that report, as you can see, is that it was a dust buildup in the living room ceiling, pretty much.
Yeah,
But
I'll get to the
Okay.
the dust in a
Sure,
minute,
sure.
but apparently under 2.0 of the report, the introduction, it says upon arrival to the project site, removal restoration efforts appeared to have commenced prior to the site visit. Can you describe what those restoration efforts were carried out by the landlord?
well, like I said, we were under the assumption that the mold was in the bathroom. So again, we hired the plumbing company to fix the leak. We leave it open to make sure that there was no water coming down from the unit above. And after it was all clear, we closed the ceiling, patch it up, and paint it again.
Okay, and have you done any remediation work since the report was submitted to the city?
No.
Okay. Let me just go over some of the language in the report to address some of the concerns that I have. And I think council probably knows where I'm going. The report states in several areas that this was a visible inspection. In other words, it did not include invasive testing. And I'm quoting from the report. They didn't dig into the walls, the ceilings, the floors. It was a visual report, correct?
That's actually not correct, Magistrate Smith. There were samples taken and there's a lab report that follows it. So
Well, I know that I'll refer to the lab report in a second, but the report itself says it did not, the site assessment did not include invasive testing. So if that's what the report says, I think I have to accept that as fact because
I think
they were
that's-
there, you were not there.
Right, I think
So-
that's both reports say the same thing, that it was only a visual inspection.
Okay. The report further goes on to say that hidden areas of, this is under 2.0, hidden areas of mold growth and other environmental issues may exist, and areas of damage not related to the reported issue or claim may also exist and are not covered under the scope of work. My concern is that this report is okay. It's a better report than the first one, but does it go far enough to determine whether there may be mold in hidden areas that the company did not examine?
Magistrate Smith, I think that goes beyond what your recognition is as the magistrate of what's in front of you. You're asking for facts and evidence that doesn't exist and asking and speculating as to what may. If Magistrate Smith and I both do a lot of mold work, we all know there's mold everywhere. It's naturally occurring. There's no way that we would be able to know the extent of every single mold of every single property. And what is presented before by the city of North Miami is a mold report that also is simply a visual inspection and testing.
Okay.
So I don't want to get into that, but that's up to the prerogative of the city and to the special magistrate. You're on, But,
Yeah, well, we agree that there's mold everywhere.
yeah,
And that's why the lab report compares the mold inside the
And outside.
apartment and compares it to the mold outside of the apartment. And speaking of the lab report, they do find some evidence of mold, maybe not to the extent that I would consider it serious, but it does find spores in the living area. And I can't even pronounce it, but it's Basidiospores, 13 of them in one place, and Ascospores number 7 in another. I'm not an expert enough to suggest that that is a dangerous level of mold, but there was some mold in the apartment. Where it was coming from, where it existed, I don't know. But let me just say that this report that you're presenting to me is suggesting certain remediation efforts, or as they say in 4.0 findings, recommendations for corrective measures that should be implemented. And it goes into the living room, the entry, the kitchen, the air conditioning closet. Visible water damage was observed on the door frame and casing. Heavy buildup of dust was observed on the louver door and interior of the closet. Recommendations: filter was improperly installed. I think it was the wrong size. And they recommend removing and replacing the door frame and casing. It goes on to say in the note at the bottom of the page, it is possible in some cases that mold growth may be present on the non-visible sides of the material. Conducting test cuts is the only way to assess behind the material. So there are recommendations, aren't they?
Those recommendations are not mold remediation, Magistrate Smith. As you're well aware, those are to clean up an apartment that the tenant has failed to clean up herself. Dust in the ceiling, dust around the walls, cleaning around the AC. We're happy to clean and do the small removal of the frame and things of that nature, but none of this is mold remediation. There's no mold remediation recommended. And as you're aware, since you say you do a lot of mold remediation work or mold work, there's a significant difference between claiming there's mold and we can do some things to clean up the unit or make some small repairs. That's why we're here. This test or this report clearly contradicts and clearly shows by a local lab, not a lab up in Virginia, that there's no mold. And moreover, the areas that were affected by the water leak don't show any mold either. In looking at the levels, as you are well aware, there is no standard to what is considered toxic or otherwise a heavy, but the numbers and the levels that are listed in the report that was prepared by AirMD are nowhere close to what would be considered unhealthy levels of any sort of spores compared to the outside, which has significantly more spores.
All right. Which of the recommendations made in your expert's report are you willing to accept?
Well, some of those cleanings are cleanings that should be done by the tenant, including cleaning of the ceiling should be completed due to the heavy buildup of dust. That is an interior of dust because of the failure of the tenant to replace AC filters and clean her unit. If you're asking the landlord to do that, we'll go and do that. But let's put this where it is. The interior of the unit is the responsibility of the tenant. And Special Magistrate Smith, I'm sure you're well aware of the duties of the tenant versus the landlord when it comes to cleaning of your own unit. That's as to the living room. As to the recommendations of the old and previously repaired, it's already been repaired. There's no requirement there as to the entryway that needs to be done. The only other recommendation, again, is normal cleaning of the closet, which, as already testified to by Angie Bravo, is done when the tenant allows them to come in to replace the AC filters. Again, if you look at the pictures, not just in our report, but also in her own report, the filters are on the side. She hasn't replaced them. So I know that you would like for the landlord to take care of these recommendations, but these are recommendations that the tenant on a normal maintenance has not done. And even if we were to make the recommendations and do it today, what's going to say tomorrow that we're not going to be here again because the same situation happened?
No, let me clarify so that we don't misunderstand each other. I know what the tenant's responsibilities are. And I'm not going to hold you accountable or responsible for making sure that the apartment has no dust, or the floors are not properly cleaned, or the wrong filter is used. But I am going to hold you responsible if, because of something that you could have done, that you should have done, whether it's a leak or whether it's something that is coming from another unit upstairs or otherwise, if that were to occur and then another mold incident should happen, then I could hold you accountable if it's something that is within your control. The city is only interested in making sure in this particular case that there is no mold. And I agree with your position that based on the lab analysis, the evidence of spores is rather limited and is probably consistent with the rest of the property, the rest of the building, and probably every other building in North Miami. So I accept your report as evidence that that right now there is no mold, but there are potential problems that could lead to mold in the future. And all I ask is, as a landlord, and of course I know that for the most part it's the tenant's responsibility to maintain the property, but if there's mold in the apartment, even though you probably have a good claim against the tenant in circuit court, from the city's perspective, it's always the landlord's responsibility to ensure that the property is safe. So what I'm going to do is I am going to
Can I speak if you don't mind, George?
Yes. I'm not done yet.
I'd rather say first, and then you can get your decision if you don't mind.
I haven't yet made a decision, but I'm going to let you speak.
Thank you very much.
Yes, Ms. Lopez. Go ahead.
Miss Barrientos. That's the tenant.
No, it's Ms. Barrientos. It's me, Ms. Barrientos.
Ms. Barrientos, you're the tenant?
Yes. Yes, I'm the tenant.
Ms. Lopez has her hand raised, so I'm going to go to Ms. Barrientos in the meantime.
Okay, Judge, the point is, if you see my report, we have a lot of mold in the air conditioning. The dust is not dust, it's because coming the air conditioning. I tried to clean it up, but I can't. It's already there since 2020. It's not from down, it's from 2020, the dust. And in the air conditioning, the person, the inspection that they made, they opened their conditioning and we have a lot of mold in there. Everything is dirty. And the air conditioning filter, I use my air conditioning filter. I use there when my is dirty, I use that, I put in it. I change every 3 weeks because my husband had a surgery from heart, George. And those what we have here, it can go to his balls. He has last year. And I need to be careful in the room and every place in my house, in my apartment, to be clean. Because if he has infection, like he has now, he can breathe because his nose is clogged. It's because that I clean my apartment. I have extra stores. To to clean the air in my apartment, 3 in each room, 2 in my living room. She knows that. I bought and I changed the filters for everything. She said that, yes, when she used to change the filter every 3 months. When his handyman left and he didn't have nobody, she didn't come in to change the filter. I do my filter, my own filter. I have those in the side in case when I check and it's dirty, I put that one till I get another one because those are expensive. And we are 2 elderly people living in here. She knows that. I never make a complaint. And the bathroom is still leaking, Judge. I have proof. I get videos. It's still leaking. They didn't fix it at all. It's still leaking till today. If you see my report, that the problem is not in the walls or the leaking, it's in their conditioning. And I'm breathing that.
Ma'am, let me stop you. I appreciate what you're telling me. Number one, the second report says that there was a heavy buildup of dust on the ceiling. That is not mold. That is dust.
Yeah, but is that dust is coming since from their conditioning. All my ceiling is not. I can show you right now. It's only when the air conditioning is coming out. I clean it. I can't do anything else. I pass the vacuum. I pass everything. But it's coming from their conditioning. All my ceiling in the living room is clean. It's only that part that goes to the in front their conditioning vent.
The report also mentions that you're using the wrong type of filter.
The filter that I have, that is whatever they provide us. They came now. They told me that. They told me that I don't need to change. They come in every I don't know how long this now that the filter in there, but they come in, they can go in because every time that they come in, I never refuse the filter because my husband is every single day in this apartment. He doesn't know. When they come in, he opens the door, they go in, they change it. Never we refuse it. I have an extra, yes, I do, because sometimes I took from them and I put the right filter. I bought it for me and a special filter and a good quality. Whatever we have is the worst quality filter.
Okay, all right, let's stop. Okay, let's stop. I'm not going to have the city mediate or arbitrate every dispute that there may be between a landlord and a tenant. That's going to be up for a court to decide who's right and who's wrong, and what does the lease say, and what is the landlord's responsibility, and what is the tenant's responsibility. We're here about mold, okay? And if there's a leak, then ma'am, you let the landlord know, and the landlord will take whatever measures are deemed necessary to correct the leak. I am going to find that the landlord has remediated the mold issue to the extent that it is possible to remediate mold, which in some cases it is not completely something that you can do. But we're not dealing here, by the way, we're not dealing here, even both experts agree, we're not dealing here with a toxic mold. We're dealing with spores that are relatively non-harmful, and in the levels that they were found, they're not, in my opinion, they do not constitute a mold problem. But I would like, I would recommend that the landlord keep an eye on potential source and air quality, so that we don't come back 6 months or a year from now with another mold situation. So to the extent that some of the, I'm not finished, to the extent that some of these recommendations that were made by AirMed, some of those recommendations are relating to the mold issue, I would encourage the landlord to address them now instead of just letting them hang and then hoping that no mold returns. So if anybody else has anything to say, I will hear from a couple of witnesses, but I believe that all of you already know where I'm coming from. Ms. Lopez?
Hi, Your Honor. So I really just wanted to speak, just to say that I actually do stay in the apartment. I've lived there for about a year because I've been there taking care of my father since he's had surgery. Angie Bravo's been well aware.
I can't hear you.
Ms. Lopez,
Yes, ma'am.
you weren't sworn in. I have to swear you in. Give me 1 second.
Sorry, ma'am. Mm-hmm.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Go ahead.
Okay. Sorry about that. So basically, I wanted to speak and say that I do live in the unit. I've been staying there for about a year now. I moved back in, I should say, because I originally moved in 2013 at the same time with my mother. My name is on the original lease, and since then. So now,
By the way, you can remove, you can remove the document from the screen. It's no longer necessary. Okay.
So I just wanted to say I have been staying in the unit. I take care of my father. I actually take care of both my parents. And because of this situation, I work a lot. Honestly, I work 2 jobs. I'm not home all the time. But when I am home, I have noticed that I do have sinus problems now. I wake up congested and I have mucus. Like I've been a 10-year smoker, if I'm being honest. I wake up and I'm like, wheezing. And this is something new. I haven't been like this before. And it's not something, I moved out in 2018. That's when I left this apartment. I moved back in last May. And now this is starting. That's what I wanted to put out there. If she doesn't want to acknowledge me as a tenant, that's fine. She has a non-standard lease that doesn't list all the occupants over the age of 18. So that does not matter. But I wanted that to be on the record that I do stay.
Okay. Well, you know, some of these issues are typically addressed in circuit court, not in a special magistrate proceeding, because I have no way to determine whether your symptoms are related to mold or something else. And this is not what this hearing is about. This hearing is about whether or not there is mold in the apartment. And based on all the evidence and all the testimony and my own knowledge of mold, and I've reviewed some of the literature on the types of spores that were found. And I'm not convinced that the city is able to demonstrate by the standard of proof necessary under Florida statutes, clear and convincing. I am not clearly and convinced that there is any, that there's mold in the apartment any longer. To the extent that there needs to be some work to ensure that it doesn't come back, I will encourage but not require the landlord to keep an eye on it so that mold does not return. But I do not, my finding is in favor of the landlord, in that all the testimony and the review of the records indicate that whatever remediation is necessary according to their report, it does not lead to, it is not mold related. It's more of a tenant cleaning issue than it is a landlord's duty to maintain the property. Let me ask you this, Mr. Savage, is there a mold disclosure in the lease?
I will state that I haven't reviewed the lease prior to today's hearing, so I don't know the answer to that.
Okay. So without further ado, that is my ruling. I will dismiss the violation and urge the landlord to keep an eye on the apartment to ensure that there is no mold in the future. And of course, if there's a leak, that could potentially cause the humidity necessary to enable mold to grow. So anyway, I think we're done, and I wish everybody a good day, and hopefully these issues can be resolved amicably. If
Anything is gonna be resolved, George, because you
Okay.
let me here in this apartment with
Thank you,
mold
Magistrate
in the air conditioning. You doing anything for me because we are two elderly people here. She's not gonna fix that. She's not gonna
Okay.
fix. And the air conditioning never was fixed and never is gonna fix. And that is the problem in here.
Okay, the problem, ma'am, is that you do not quite understand why we're here. I'm not here to compel the landlord.
I do
to fix
understand.
your
The
air
only I
conditioning.
want us.
You're interrupting me, and ma'am, you're interrupting me. And you're not understanding that I'm not here to tell the landlord to fix your air conditioner. That's not what this is about. If you want the landlord to fix your air conditioning, you have to go to court. I can't do that for you. This is not the right forum for to order the landlord to fix your air conditioning or to fix anything. That's up to whatever the lease require, whatever the lease terms are. That's a matter for the courts, not for the special magistrate. So again, at this point we're done. Okay, we're done, and we're moving on to the next case because we have a long agenda.
Thank you, Magistrate. Have a good day.
Thank
Okay.
you. Thank you. Bye.
All right, let's move on.
Magistrate, the next case I'm gonna call is 775 Northeast 138th Street LLC in care of Brian Pristup and Associates. Case number is CEBPR 2022-00578. This case was previously found guilty with an abatement date of May 18, 2023. Fine set at $250 plus $100 cost assessment, and the officer is Jannar Murillo.
What's the number on my agenda?
22.
Okay,
Give me 1 second as I allow the attendee. Waiting on him to accept the invitation. All right, Alan, please enable your audio and video.
Hello.
all right, Sadie, go ahead.
Alan, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
All right, sir, tell me what this case is about.
My name is Alan Cableton, and I work for the defendant company, and I'm based in the UK. The property in question at 775 138th Street is one of a part of portfolios owned by a UK investor, and the investment was routed through the US via a company called Lord Furdo Corporation, whose registered office is at the accountant stroke advisors Brian Fretzer. There may have been some miscommunication somewhere along the line, but the first we knew about the violation was in a notice to appear dated the 6th of July 2023, which was received by us via an email from the accountants on the 18th of July. And this was the first we knew about the violation. We immediately spoke to our local agent out there who said that they would contact the city's offices, but I'm not sure how far she got. On the 24th of July, we reached out to Mr. Murillo by email, who kindly responded on the 26th with a link to the website, which would enable us to download the after the fact permit.
Sir, who did you have contact with? What's the name of the individual?
Gennaro Morello, the gentleman attending, Mr. Morello.
Okay.
Yeah. The link he gave us, we did go on to, but unfortunately we weren't successful in tracking down this particular form. So we then emailed, I think it's permits@northmiamifl.gov, and received an automated response on the 31st of July, saying that they would get back to us in 1 to 2 business days. And unfortunately, we still haven't had a reply. Clearly, we want to comply with the local regulations and complete the permit and pay any fees due. And all we will ask is that someone somewhere either direct us to exactly on the website where we can download the form, or in fact send us the form. Now, it may or may not be relevant to the case, but as far as we are aware, the work that's in question was carried out in early 2015, and that followed the purchase, which was completed in December 2014. Clearly, we want to comply. We have no reason not to comply. So if someone can send us the form, we'll do it.
All right, let me give you a little background, and maybe you can explain to me why we're still out of compliance. I heard this case back in April of this year and found the property guilty of the violation and provided an abatement date of May 18th with a fine of $250 per day for the violation. Are you saying you never got notice of that?
No, the first notice we had from our accountants that we knew about this violation was the one dated the 6th of July. We didn't know anything about the hearing that you just mentioned. Just astounded that we didn't know anything.
Okay, let me, by the way, I reviewed the file, and the manager of the LLC is someone by the name of Brian Sistup.
Brian is the accountant for the company. The business, Brian Pretzup, however you pronounce his name, he is the accountant and tax advisor for the company, and we use his offices. And he's been in situ acting, well, liaising and being a local, should we say, receiver of documents and that since 2007.
What is your position with the company? What title do you hold?
I work for the company in the UK, so I just manage their affairs.
Okay,
and I work for the shareholder who is also based in the UK.
So the principal owners of this property are in the UK?
Yes.
Okay, so I'd like to hear from the city, Mr. Murillo, what efforts have you made to either contact the property owners or otherwise provide good and sufficient service? Because that's the issue here. They claim lack of notice, and if the notice was defective, I have to set aside the order that I entered. So tell me why I shouldn't set aside the order.
Well, magistrate, when this violation was opened on June 14, 2022, right? I spoke with Carlos, which is he lives on the property. He always mentioned that he was a family member of the owner of the property, Carlos, which he was the one who was in the last hearing representing the property.
Mr. Capleton, who is Carlos?
He's simply a tenant. He has nothing to do with the owner whatsoever.
Well, in the last magistrate, in the last hearing, he was present in the hearing.
Wait. Let's not do a back and forth. I was just asking who Carlos was, and you're telling me that he's a tenant. I accept that.
He is a tenant of the property. He does not own the property. He has lived there, I think, since about 2015, but he is not the owner of the property.
Have you given him any authority? Is he a manager?
No tenant whatsoever has any authority to act on our behalf.
Magistrate, in this case, I read Mr. Allen email, and he explained everything, what happened with the property, and he was not informed about the violation. The link that I sent you, it was not for the building permit. It was I was going to grant you an extension.
Oh, right. I got confused by the word.
Yes, there was maybe a misunderstanding there. It was for you I was going to grant you an extension.
All
so
right.
That way I could give you more time to apply for the permit, since you mentioned you was never notified about the case.
No, that is a misunderstanding, because I just said where it said in the violation description, please obtain an after the fact permit. Now, I just assumed that there was such a form that needed completing. It's clearly a misunderstanding between the two of us as to what action was required by that
Okay.
link.
Mr. Capleton, is that how you pronounce it?
Yes, that's correct, sir.
Okay. The city has a process, or this happens all the time. People in good faith do work. They paint, they stucco, they put up a fence, and then they realize they needed a permit to do that, and they get cited. So the process is the code inspector finds that there's a violation, and then says the reason you got a violation is because you did not obtain a permit. So there is a process in the city that allows you to go and make an application with the building department. What you do is you have to hire a design professional, whether it's an architect or an engineer. You gotta present the city with the plans as shown, as reflecting the work that was done. The city sends an inspector. If everything is according to code, you get a permit. And it's a very simple process. All you need to do is work through the building department, not code. Code is not going to tell you how to process your application with the building department. That's how it works.
Right. Okay.
So if there's no objection, then what I'm going to do is I'm going to table this case for a period of 60 days to allow you, sir, to retain a local architect, engineer, contractor, and make the necessary application to the building official so that the work that was done can be properly permitted. And that's why it's called after the fact permit.
Okay, sorry, that's my misunderstanding. I apologize.
Okay, no, the process itself is simple, but a lot of people don't understand how it works.
No, it's very kind of you to explain it. Thank you.
Okay, so if you're willing to do the work within,
Yes.
and get your permit within the next 60 days, I will table this case, and you don't have to worry about any fines. Okay.
Okay. No, but we will start straight away. Thank you very much.
Okay, but you need to hire somebody local that understands how our building code works.
Yes, indeed. We've got.
Okay.
Yeah. Thank you very much indeed.
Okay, thank you, sir. How are things in the UK?
Rather chilly, believe it or not.
Good.
We're not like the rest of Europe. We're sitting here today and it's about 19 degrees centigrade and very wet.
As usual this time of year. All right, sir.
Yes,
have a great,
typical
have a
English
great
weather.
day. Okay.
Thank you.
Bye.
Bye-bye. Bye.
Next.
The next case magistrate is item number 23, Alan Lacrosse and Adele Elvey. Case number CEBPR 2022-00683, and the officer is Gennaro Murillo.
All right, Mr. Murillo, why don't you go through the file and educate me on what this violation is about? I want to see pictures of the white fence again.
On September 15, 2022, a violation was opened for the property address 965 Northeast 138th Street. This was to obtain an after the fact building permit for the white fence that was installed on the property. I had an inspection on September 26, 2022, but there was no compliance. A notice to appear was posted on July 9, 2023. It was also mailed at July 13, 2023 as my final inspection on July 2023. There was no compliance. The application, well, yeah, no compliance. All right.
All right, anybody here on behalf of the owner? Alan LaCroix, Adele Elvey? Either one?
We have Alan here. Alan, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Sir, for the record, state your full name, your address, and your relationship to the property.
My name is Alan Lacroix, address 965 Northeast 138th Street. I'm the property owner.
Do you understand the nature of the violation that was issued on your property?
Yes, I was being aware of the violations, and we're currently working and we filled out the applications for the permit, and it's at the beginning of July. So we
Okay,
hope.
so you must have been listening to the prior case.
I'm sorry?
Were you listening to the prior case with the
Yeah,
fence
I was listening to, yes, correct.
or the stucco or whatever it was?
Yeah.
All right, how much time do you need?
The application is in the city right now. If I get 60 days to file out everything, I would appreciate that.
Okay, Madam Clerk, when is my abatement dates?
Your abatement dates for today's hearing is September 21st, October 19th, and November 16th.
October what?
19. That brings you to the November 2nd hearing
And then the third one?
is November 16th.
Okay, I'm gonna give you, these are abatement dates, correct?
That is correct.
Okay, Mr. LaCroix, I'm gonna give you until October 19th to obtain the after the fact building permit for the white fence. It should not be a lengthy or difficult process for you. If you are acting in good faith and moving the permit along and you come back and you tell me I just need a few more days, I'll consider that. But based on the unrebutted testimony of the city's code compliance officer, the photograph and evidence presented depicting that the cited violation still exists, proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of October 19th, 2023. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Good.
All right, you got some time there, sir.
Very good. Thank you very much. I appreciate
All
it.
right. Next case.
The next case I'll be calling is item number 26 through 27. Anna Halliday and Norman Halliday and Don Halliday. Case number CEBPR 2022000472. This case was previously found guilty with an abatement date of April 20th, 2023. Fine was set at $250 plus $100 cost assessment. And as for item number 27, it was also previously found guilty with an abatement date of July 20th, 2023. Fine was set at $250 plus $100 cost assessment. Gennaro Murillo is the officer.
All right, Mr. Murillo, bring me up to date on these cases. Magistrate 26 I handled back in December of last year, 2022. And case 27 was handled by Magistrate Kazoo in June. So tell me where we are today.
Okay, so based on my notes here on item 26, right, for the property address 820 Northeast 143rd, it was to obtain an after the fact building permit for the new driveway. This case was opened on March 31st, 2022. In order to comply was posted on December 22, 2022. Give me a second, I just have a lot of notes here. Okay, so I had the notice to appear posted, okay, on July 9, 2023. Based on the final reinspection, it says that the permit was denied. I guess they still need to do some corrections in the building department. And you want me to proceed with item 27?
No, let me ask you a question about 26. I made some notes myself. And I wrote in my notes that there had been prior work, a remodeling that had been previously legalized.
Mm-hmm.
Is that accurate, or did I make it up?
Say that again, I'm sorry?
In your file, which I reviewed, there's some language that there had been prior work, not the driveway issue, but some other issue that it was like a remodeling type of work, and that had been previously legalized properly with the building department. Is that something that is in your
No,
records?
No.
No. Okay, so we're only talking about a new driveway.
Yes.
Okay, who's here on behalf of the owner?
We have Spencer Schwartz.
And I'm also the owner. I have to leave for work soon, and I was hoping he could catch everyone up to speed, but I can stay on for a few minutes. But I'm Anna Halliday, and this is my husband, Spencer Schwartz.
All right, can
Okay,
you, both of you guys raise your hand, please? Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God, please say I do.
I do.
okay, according to the style of the case, the title, the owners are Anna Halliday, Norman Halliday, and Dawn Halliday. Mr. Schwartz is your husband, right? And you are Anna? Okay, you have to answer out loud so the recording device can hear you.
Sure, yes, I'm Anna Halliday, and this is my husband, Spencer
Okay.
Schwartz.
I found I found you guilty back in December because no after the fact building permit had been obtained. And I set an abatement date of April with a fine of $250 per day. Do you understand that you are currently out of the abatement date and possibly incurring fines?
No, we were never aware that we would be incurring fines. We actually had another hearing in June, I think.
With a different magistrate?
Yes.
Yeah, well, that's after the that's for our new two new air conditioners. This hearing right now, what we're talking about is the driveway.
We
And-
also had one for the driveway in June.
Okay,
It was for both.
that's the one that we're hearing right now, and that's the one where I entered an order. And I want to know what you have done since December of last year to get an after the fact building permit for the driveway.
We did submit the permit and we got notes on it a week or a week and a half ago that we're going to correct this week. Spencer will go back in and complete the permit as per the notes that we received.
What took so long?
Well, it wasn't, so when we bought the home, the previous owner, the seller, did all this work unpermitted, and I bought it with a conditional reoccupancy to, fix these permits in a certain amount of time, but I also had an agreement with the seller in our contract that they would actually complete it because they did all the work and had all the information, and so we gave them a period of time to do that, and they failed to do it, and then it became our responsibility. But we've been on top of this. We hired the architects and everything.
And the contractors.
And the contractors. So we got all that information on our own just within the last 4 to 6 months. We also just had a baby, which I know is not an excuse, but we've been very busy with our personal lives. But we have been on top of this as much as we can and trying to get it going as quickly as possible.
How much time you think you need to get the after the fact building permit?
Well, all our permits are submitted and we're just working on the notes now. So I don't think it would be more than 2 or 3 months to get things
Two
wrapped
or
up.
3 months with everything
Yeah.
submitted? Shouldn't take more than 2 or 3 weeks.
Okay.
Mr. Murillo, what are your thoughts on this? Were you aware that paperwork had been filed with the building department?
Yes, sir.
Okay. So as to the driveway, and I'm not going to grant any more extension. I'm going to table this. I'm going to table this matter of the driveway. Mindful that you had a baby, boy or girl?
Oh, boy, he's
Good.
almost 4 months now.
I know how busy that can make someone. My son just had not him, his wife had a little girl, and she's 2.5 months. And I know how
Wow.
difficult it is the first couple of months.
Thank you.
They never sleep, and they're always throwing up. So,
Thank you.
or pooping. Okay, so I'll give you until October the 19th. October the 19th to get your after the fact building permit. So we're going to table that until then, okay?
Okay, and is that just for the driveway or
No,
for
now we're going to talk about the other case, which is the new air conditioners.
Okay.
Apparently 2 new air conditioners were placed. You were found guilty by Magistrate Cazot on June 1 and given until July 20th to comply. What's the issue with the air conditioners?
Those were also installed by the seller and were part of the, the reoccupancy that I needed to obtain. But we also submitted permits for that. We haven't received any notes yet. So I know Spencer will follow up with that when he goes in to complete the driveway permit.
Okay, absent some, act of God, October 19th is the date I'm going to require you to get all of these permits.
Okay.
If you do not get these permits, unless there's something out of your control, somebody dies in the building department or, some tragic, get a hurricane or something. If you fail to comply by October the 19th, I'm going to retroactively impose daily fines, meaning that the fines will begin when the original abatement date was set. So on the driveway, the fines will accrue as of, let's see, 26, case 26. On the driveway, the fine will start accruing as of April the 20th. And on the air conditioners, the fines will accrue as of July 20th.
Mhm.
So you have to get this done. You need to, hire someone to help you do it, design professional or whatever you need to do. Going to be cheaper than me imposing daily fines for your failure to meet your obligations by the abatement date. And I know that it's unfair when you buy a piece of property from a seller, you assume that everything is correct, but sometimes, when you buy a property, if you check around, you may find that there's some problems, and usually a lawyer would discover these problems and tell you how to get things done. So thank you. Paul is well with the baby, and I'll see you. Maybe not, but if you get everything done, you won't have to come back before me. But if you're not in compliance, you will, and it's gonna cost you. Okay.
And I just want to clarify, I appreciate you being understanding. Are you expecting us to have the inspection and everything done, or just to complete the permits and be in that process to schedule the inspection?
I'm very familiar with the process. It doesn't take once you get the paperwork in,
Okay,
the inspector will go out probably within a couple of days after you get your paperwork, maybe a week, at the latest 2 weeks, and go out and do the inspection.
okay,
And then they will report back and say, everything is fine, everything is in compliance, and you're done. If, again, as I said, if there's an act of God and the inspector dies, God forbid, or there's a hurricane and they can't go out there, and you have a great excuse, I may grant you an additional extension. But don't sit around and not do it because it's going to cost you. Okay.
okay, thank
All right.
you.
All right. You're welcome. Next case.
The next item I'll be calling is item number 28 and 29, which is Aruba Investment 155 LLC. Case number for item number 28 is CEFOB 2022-00143. And item number 29, case number is CEZCU 2022-00290. Jose Perez will be presenting this case.
All right, Jose, this is a new case. The first one, 28, is a business tax receipt issue. Tell me a little bit about it.
Sure. So this was a list that was received from the business tax receipt office advising of all the properties that did not have a business tax receipt and certificate of use at the time. So a proactive inspection, well, actually a reactive inspection was done thereafter on March 9, 2022, which the property owner was notified of the restaurant. Kaz restaurant was out of compliance with regulations by not obtaining the certificate of use and business tax receipt prior to engaging in business in the city of North Miami. At that point in time, the property owner reached out. It was either the property owner or the business owner. I can't remember at this time. They reached out on March 23rd, 2022 and requested an extension. One was granted until April 13, 2022. They advised that they would be going through the permitting process to obtain licensure. It was brought to my attention that they are now having issues with the Durham department as it relates to the issuance of their business tax receipt, which has taken quite some time. Unfortunately, it's been over a year now since they've been in the process of obtaining the licensures. They've still been operating for both cases. Basically, the city at this time is requesting just an adjudication, and we're okay with granting them more time. However, they've been very informative as to their statuses. It's just that the duration of this is taking quite some time. I believe there has been some changes to their plans, which delayed the process with Durham.
What brought it back to Durham? Are they a new business? Are they expanding? What is the Durham issue?
I believe they're expanding, but I'll let Mr. Rubinsky speak on that behalf. Alexander Rubinsky is the business owner for the restaurant.
Okay. All right.
Hello.
Let's
Mr.
Mr. Rubinsky. Tell me why you have not been able to get a business tax receipt. By the way, identify yourself. Tell me what your relationship to the property is. I'm showing Maria Garbati as the manager, as one of the managers of the LLC. Tell me how you fit in this whole picture.
I don't know who is Maria. I am the husband of the business owner. My wife is Katerina Shabalina. She's right next to me here. We got
Sir, before you begin, I need to swear you in.
Oh.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Okay. Sorry to interrupt you, but go ahead. Tell me how you're involved. Tell me how you're involved with the property.
As I said, I'm the husband of the owner of the business of the restaurant Kafkaz, and I'm helping with all the things related to permitting and construction, because that's what I do. I'm a project manager in construction. And basically what happened is that there was some additional structure on the premises that was built, like it wasn't like a full structure, just a half walls. We were not aware that this requires an additional permit, and we were advised that we will need to resubmit the plans, and that's why the certificate of use was not in compliance. So what we did, we basically last year, as soon as we were notified, we submitted the application to the city over online, and unfortunately it didn't process to anywhere. And at that time, me and my wife, we were living in Canada with our kids. And last year we moved back to Florida in August, and right away went to the city. For some reason, the application didn't go through. So we had to resubmit it in person in the city or in the building department. And from that part, because we wanted to increase our business from the capacity of 80 people to 150 people. That way we can get a license for hard liquor, which we don't carry right now. We submitted the plans to the city, and the city said because we're increasing the capacity, it has to go through the county with them to review that. As soon as we submitted to the county, after a month or so, approximately, we got feedback with comments saying that we need to resubmit all the plans for the DERM with the new grease trap system, because according to the new code of the Dade County, the grease trap is supposed to be 99% efficient, which is a new system, which we need to incorporate into our plans. So we hired an architect and an engineer to work on that. They recently completed the plans. The main problem is that I tried to get in touch myself with the county and send them a couple of emails, but unfortunately I didn't get any feedback from them. So about 3 weeks ago, we hired a permit expediter to help us with this matter. And now he's going to be working on that. So according to what we're getting from the permit expediter, it will probably going to take about 2 to 3 months to get it right and to go through the process of construction and changing the grease traps to the new system grease trap, the one that is required right now by code by the county. So our request is to get us an additional 90 days to comply.
All right, you mentioned the certificate of use, which is the next item on the agenda. We're actually talking about the business tax receipt right now, but I know you can't get a business tax receipt without a certificate of use. Is the restaurant doing business, or it's shut down?
No, it does business.
It is doing business, so that this is an expansion to allow you to have more customers.
Correct.
Right, and you've got all the plans already, and just waiting on DERM. What's the issue with what's the issue with DERM? They asked you to get a system that is 99% effective, the grease trap, and you had filed plans that did not comply with that requirement, correct?
Correct.
All right, but you're fixing that.
That is correct.
You're asking for 90 days.
Yes.
Okay. Jose, is this your case?
Yes, the city has no objections with granting 90 days.
Okay, so does anybody else need to say anything before I enter my order?
Yes, I do. Special Master, my name is Juan Sorales. I'm a partner at Jones Walker here in Miami. I'm appearing on behalf of the defendant, Aruba Investments 155 LLC, who is the property owner and the owner of the shopping center. These violations have been issued in connection with the tenant operating its business in our shopping center and its space, pursuant to a lease agreement that it has with my client. Our lease specifically provides that the tenant is required to obtain all required permits and licenses from the government in order to operate its lawful business. It is my understanding that these violations, that the property owner is cited with the violations, not the tenant. The property owner and landlord is not the permittee. It's not the licensee. It cannot cure the stated violations. That's something that the tenant has to do. And the property owner is not the one in violation of the code. So if, to the extent that the property owner is cited for these violations, I think that that's incorrect and it should be dismissed.
Well, I know it's counterintuitive and your argument is persuasive.
I mean, if they don't correct the thing, the property owner is going to be subject to fines, not the tenant.
Because the violation is occurring on your property. The city has a right to issue a violation to the owner. The owner's remedy is to ask the tenant,
I guess,
to go after the tenant for indemnification or violation of the lease, and handling it in a separate civil matter before the circuit court. But the city always takes the position, and Mr. Perez, you can probably explain it better than me, why it is that the owner of the property is always on the hook for any violations committed by its tenants.
I read
Mr.
the
Perez?
ordinance 1323 and I understand the logic of it. I just think that I want ample time. I'm glad that they're cooperating with one another, but it's really, this is not the fault of the property owner.
I understand, and I'm going to be very lenient when it comes to holding a property owner responsible for the actions of a tenant. Remember, you have a lease, and there are certain things that you can do, like termination, which will immediately bring this case to a conclusion if the tenant doesn't comply.
My only point is that the tenant ought to be at least a co-violator subject to the remedies of the city.
Well, for whatever reason, the city chose to go after the owner. Perhaps the next time around, the city will cite the tenant as well to put a little pressure on them to comply. Mr. Perez, how do you respond to that?
Well, basically, the tenant was named on the notice violation. Therefore, they're both on the hook, quote unquote, for this violation. Unfortunately, as it relates to the violation from the city, the violation goes directly to the folio number, which is owned by the property owner. It is therefore the responsibility of the property owner to ensure that their tenants are abiding by all local, county, and state regulations, whether it be licensure or any other miscellaneous regulations. The property owner is ultimately responsible for anything that occurs on their property. If there's a violation of a lease, that's a civil matter, but in the eyes of the city, it is the responsibility of the property owner to ensure that all tenants are up to date with their regulations.
How long will be the abatement period?
I will rule in a moment. Mr. Sarayes, this is similar to an ADA violation. Anybody that owns property in South Florida at one time or another has been sued for ADA, even though the owner may not be in control of the property of, let's say, a restaurant, and let's say the bathroom is non-compliant with ADA, the owner is going to get cited. It's just a fact of life living in South Florida, and then the owner has certain remedies. So I heard your client say that he needed 90 days. I'm gonna give you until November the 16th, and then we'll see where we are at that point. So you're not going to be cited. You're going to get some time until November 16th, and then we'll see where we are. And if again, an act of God, or if Durham doesn't give you the response within that period of time, then we'll have another conversation. But for now, the abatement date will be November 16th. So based on the testimony of the city's code compliance officer and the evidence presented depicting that the violation for the lack of a business tax receipt has not been complied with, proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of November 16th, 2023. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. So I assume that case 29, 29, we're going to treat it the same way, correct? Because there is, Mr. Perez, there is no certificate of use for the restaurant. Is that correct?
That is correct.
And the reason is that we have some issues to resolve with the building department and Durham. So same ruling based on the testimony of the city's code compliance officer and the evidence presented depicting that the violation still exists. For the lack of a certificate of use, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of November 16, 2023. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Again, if you can't do the work through no fault of your own by November 16th, as required by my order, we can have another conversation and I'll grant you a further extension. I know how difficult it is to work, to deal with DERM. So, and grease traps in particular. So I'm mindful of, and you have a tenant who apparently is not doing what he or she is supposed to do. Landlord has remedies. I would exercise those remedies. I would advise the tenant that ultimately the tenant will have to hold you harmless for any violations and deal with it in that fashion. Hopefully that'll light a fire under the tenant, make them act a little quicker. So those are my rulings on these two cases. You both have a great day.
Thank you.
Thank you.
Okay.
Item number 30 and 31, Bayview Palms Condo Association. Case number for item number 30 is MHVIO 2022-00401. And item number 31, case number is MHVIO 2022-00403. Both cases was previously found guilty with an abatement date of July 20th, 2023. Fine was set for item number 30 at $500 plus $100 cost assessment. And as for item number 31, fine was set at $250 and $100 cost assessment. Gennaro Murillo is the officer.
Mr. Murillo, just to refresh my recollection, can you put up some pictures reflecting the stucco work made in the parking lot without a permit?
Yes, sir. 1 second.
Okay, I remember it. Yep. Is this a garage?
Yes, sir.
And Bayview is the management company?
No, Bayview is a condominium.
Okay, gotcha. All right, who spoke?
My name is Aldo. I'm the property manager of the association.
Aldo, before you proceed, can you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
All right, Mr. Rojas, you're obviously familiar with the violation. I entered an order back in May of 2023, gave the association an abatement date of July 20th to get an after the fact permit for that stucco work that was shown in the pictures, which was done in the parking lot. Why are you out of compliance?
Well, we actually already applied for the permit. So first of all, GC, which is the contractor that we hired to do this, made the application back in May, and then it was declined, saying that the work was actually worth more than the whole building, which is not true. The work is only going to cost us only $5,000. We even provided an appraisal as well, saying the value of the building, which is a lot more than what it costs to actually make this. So it was rejected as well. So we got it with the engineer, got a letter from the engineer, which it was submitted like a few days ago, to see if it finally gets approved. So I'm not sure why it has been declined before, but I provided the letter. I went directly and provided the letter because a copy was not allowed. So I had to actually go to the engineer, get the letter myself, and give it to the contractor. So I'm just waiting on response from the city to see if it's finally approved.
Mr. Murillo, do you have any knowledge about what has been done since the abatement date?
Yes, I see the permit here. Sorry.
The application?
Yes, the application.
And it was rejected because
yes,
the value was underestimated. Is that what?
I
it showed?
see? Let me see the notes here. It says it was class rather to flood. It was denied. It says appraisal submitted is not acceptable. Please see file for 50% rule. So you need to get in contact with the building department. I see there was a deny, well, yesterday.
What does the 50% rule have to do with stucco?
I don't know. That's why you need to get in contact with the building department in case you need
Is
to
there
submit something
anybody,
else.
I know the building official is not present, but is there somebody from the building department that can shed some light on this?
No, there's nobody
And
here
at the
today.
moment,
No.
Okay, so it was denied, does it say why?
Well, what I read right now says appraisal submitted is not acceptable. I don't know. They need to get in contact with the
Mr. Rojas, do you know why the appraisal was not acceptable?
It didn't give me an answer. What I did actually found out is that we needed to get like a letter from the engineer showing proof of how much it was going to be the project. That is not worth more than the whole association, both buildings. So that's why I submitted the letter already. I gave it to the to GC Construction. They submitted it, I think, 2 days ago, because since we saw it was declined, I'm like, why did we get a decline with the appraisal? So I didn't even know why. So that's why we provided this letter in hope that then it's going to get approved now.
What does the letter say?
I believe I sent a copy to Gennaro, but if not, I can provide one.
Gennaro, do you have a copy of a letter?
When
I'll send you an email.
Give me a sec.
Mr. Gennaro, have you gotten a letter?
Yeah, I see something here. Give me a second, Your Honor.
Okay. Mr. Rojas, I really hate to punish the association. I know how difficult it is, and dealing with building departments is often difficult. But your association had a warning since back in May, because I had issued an order which would become a lien against the association. I don't know why it took until yesterday or the day before yesterday to identify a lot of these issues. What's going on there? Is the board not acting, or I mean, what is?
Well, we had a lot of change in boards. That's what happened. I mean, I've been only there for a year already, so it's been kind of tough with the board. One board wants to do something, another one wants to do another one. So we, one of those boards that was actually back and forward got out of the board, and the other one resigned. One was the treasurer and the other one was the president. So those two are out of the board. We had to actually do an election again in March, I believe it was. I'm sorry. And then they didn't even show up to the meeting, so we had to stay with the same board. Once the other one got out and resigned, then we finally got two other new board members. We do have a new president and a new treasurer, so they're more active right now. They know what's going on. I'm informing them what's going on, what has happened in the past. So they're acting right now fast. And I will tell you more about it on the next case, what has been done as well that wasn't done before. But I mean, we're moving forward. We're trying to apply even for loans already, so we can start, this project, or if not, pass on a special assessment, which us as the management company has been advising to do from a long time, and it haven't been done.
Does the association have an attorney?
They do.
Maybe the attorney needs to remind them about the Champlain Towers situation, because if something happens out there, even the attorney is going to be liable. Okay? And they know better. So what I'm gonna do is I'm gonna table this case until my next my next hearing. I'm gonna table it. And I want the president to be available on Zoom to tell me where things are, and if I'm not convinced that everything is being done to remediate these conditions, I'm going to impose the fines retroactively, meaning that the fines will start accruing on as of July 20th of 2023 at $250 per day. Okay.
Okay,
So I don't like the fact that boards do these things and then they send a manager to ask for give us an excuse or ask for some consideration if they don't have the wherewithal to be here to explain to me why it's taking so long. So I want the board to know, I want the president to know that if by my next meeting, we don't have an after the fact building permit, the fines will start running. Okay. So
okay.
that's whenever my next hearing is, Madam Clerk.
That would be November 2nd, Magistrate.
Okay, so I'm gonna give you till November 2nd to do
Okay.
everything you need to do.
Okay,
If you're not done by November 2nd, your fines are gonna make it very bad for that board that's sitting there now, because all the residents will know then that fines are accruing, and you may need to file for a special assessment in order to pay for those fines. And the reason those fines will be imposed is because the board has done nothing since May of this year. So that's what we're gonna do with this case. That is the last time, the last extension that you're gonna get on this case. All right?
okay.
Same thing-
May I ask a question, please?
Yes.
My question is in regard to the stucco on the application. What's gonna happen with it? Because we've been declined, it's only $5,000 what it costs to actually fix it with the contractor. So I'm not sure why.
I am sure that the building official in this
Okay.
city is reasonable enough and nice enough to understand that stucco work does not exceed the value of the building. Okay,
That's what I was thinking.
somebody there is not understanding the 50% rule, and somebody there doesn't understand. Maybe the appraiser left something out, and maybe the appraiser didn't specifically set forth the value of the work. I don't know what happened, but the city does not require you to pay a fee that is more than the value of the building. It just makes no sense. Somebody dropped the ball on that one. So if that's the case, next meeting, we'll have the building official here and we'll figure out exactly what the facts are. But
Okay.
it's unbelievable that anybody would ever say that the value of the stucco is more than the value of the building, or that you have to do something under the 50% rule. So just, speak with Gennaro, speak with the building official, speak with your appraiser, and get it done again by November 16th. Okay?
Sure, yeah, we'll get that done right away.
All right, the same ruling on the structure in the parking lot. Apparently there's some things there that need to be fixed. Let me see the pictures, Gennaro, on that. Is it a life safety issue?
Give me 1 sec. Thank you.
Is that the violation, the structure in the parking lot?
Yes, Your Honor.
That you're showing me
They
what
have-
rebar?
Yeah,
What are
so
those
they have the second floor closed, that nobody can park on the second floor.
Mhm.
The building official said that nobody can park on the second floor. and a violation was open. Per what the building official requested to repair the parking lot.
All right, as to this particular violation, I want to hear an answer, because this appears to be a lot more serious. So as to that one, we're going to set an abatement, not an abatement date, but I'm going to table it until October 9th, on my next hearing, which is when?
Your next hearing is September 7th.
I want a full report at my next meeting, September 7th. And I'd like the building official to weigh in on whether this is a life safety issue or an issue that requires that the building official red tag certain areas of the building or the whole building. This, to me, appears to be a hell of a lot more serious. So let's do a review of this case on September 21st.
No, September 7th. is
I'm
your
sorry,
next-
September 7th, correct.
Okay,
And Mr. Manager, property manager, Mr. Rojas, I would worry a hell of a lot more about these cracks and the issues identified in the photographs than I would about the stucco. So you better get, some building expert to help you with it and possibly attend the next meeting along with the president.
yeah, no problem with that. As a matter of fact, what I wanted to add about this one, the board already signed the contract with the contractor to start working on this. And I'm about to actually pick up everything right now at the office so I can send it to the engineer, because it requires a lot of engineer sketch and stuff like that for the application for this one. So I'm gonna do that like today, pick up everything, take it to the engineer, everything that needs to be signed from the board, so we can start submitting the application for this, okay? For the permit.
All right, I want you to note how serious these conditions are. Again, I'd like the building official to give me some guidance on some life safety concerns. So we'll reschedule that on September 7th, which is my next hearing date.
Mhm.
Now, may I ask another question in regard to this?
Yeah, quickly, because we got to move on.
No, I understand. I mean, right now it's just gonna be the application for the permit process. After that's approved, that's how then we start working on it, correct?
Yeah,
Okay, so how long pretty much it's gonna take to get that approved?
I'll tell you on September 7th.
Okay, so as long as we are on track on doing that, there was not gonna be any problem,
You
right?
you do everything you need to do between now and September 7th.
Gotcha.
And you then tell me on September 7th where you are in the process. Hopefully by then you've got a building permit.
Okay,
And the building official will then advise me on any remediation or safety issues, or maybe you have to provide some safety precautions, scaffolding, or whatever. And we'll be more informed than where we are. And you may want to bring your engineer, your contractor with you to explain to me, because property managers do a lot, and I appreciate what you're telling me, but you're not experts on building, engineering, and
Correct.
structural issues. So I would rather hear from those folks than from the property manager. Okay?
okay, I'll bring the engineer next time then.
Yeah, I want a complete explanation of what's happening and when are we going to be done with this. I don't want to keep this on the agenda forever.
Okay, no problem.
Okay, all right, thank you.
Thank you.
Next.
The next item I'll be calling in is Lautaro Desiano. Case number is CEGMP 2022-00113. This case was previously found guilty with an abatement date of May 18th, 2023. Fine was set at $500 plus the $100 cost assessment. Gennaro Murillo is the officer.
What's the case number?
41. Sir,
Okay,
please,
Mr. Murillo,
sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
all right, I found the property owner guilty on April of 2023. I set a fine of $500, probably because the property owner didn't show up. And the issue here is pressure wash and repaint the building. Gennaro, just for the record, show me the pictures again so it refreshes my recollection.
Yes, one moment, please.
You see the condition, go back to the first picture. The first picture that you showed me has some stain marks between the windows. And what do you consider that, mold?
Yeah, like stain,
Yeah.
model.
Yeah, well, it doesn't look pretty. Door. Okay. What else? Looks like there's nobody living there.
Well, they, yes,
Show me
they-
show me the front. That's the door. Okay. All right. All right. That refreshes my recollection. Who's here on behalf of the property owner?
Lautaro Deciano, my name.
Okay, Mr. Deciano, have you been sworn?
Yes.
Okay. So you were found guilty. The property is still out of compliance. What's the problem?
Well, we have an eviction with the old tenant. We came to an agreement. They were going to leave. They left on July 12th, I guess. We didn't have any access to the property. We couldn't do any work. On top of that, a week before they were leaving, the property got fire. The kitchen we have some fire. We have a case. We have a report from the fire department. So in order to do all this work, we need first access to the property, and then we needed the electrical was compromised, so we needed an electrician to check all the electrical. So we had an electrician visiting the property. We start with the painting. Now the paint is done. I have pictures of the house, water pressure, and also what else? Yes, we are doing a modification. We presented the permits. We are approved by them. And now we are waiting for building to have approval. I have the process number with me if you need it. That's basically, but the property is already water pressure and paint.
Okay, that's all this violation is about. This is not about electrical, plumbing, structural. This violation is about pressure wash and repaint. Mr. Genaro, did you look at the property? Have you been back to the property or seen pictures reflecting remediation or the
Well, he might did it. He might did it after my final inspection, because when I did the final inspection, the property was in the same condition.
Okay, Mr. Deciano, have you sent the pictures to the code officer?
Yes, I sent them. I submitted the pictures and with the case number through the website. You have a site to provide the pictures. I send them, and I know from the painters that Mr. Morillo or somebody from the city came by the house and checked the property, and we were painting by the time, I guess, if it was Mr. Morillo. And I'm letting you know about the electrical, because we need power in the property in order to do water pressure and paint the property. So that's why I was coming with I was letting you know about the situation with the electrical service.
All right, Mr. Murillo, what is your recommendation? He says he's painted it, he's pressure cleaned it. Do you want
Your
to?
Honor, I will have to do another reinspection since you
Okay.
say it's now in compliance. When I did the final inspection, I saw workers, the property was in the same condition. They say they might have started painting in the weekend. So I asked them to give me a call so I could do the
Do
reinspection
they need
before the
a, do they
hearing.
need a, do they need a permit
For the house, no. For that, but no.
to
They don't need a-
paint? They don't need a permit, okay. All right, bring this back to me on September 7th, if there is still no compliance. And I will ratify all the fines if there is no compliance. So, Mr. Desiano, what that means is that the code officer is going to go back and see if there is compliance. If there is compliance, that particular case will be closed. If there is no compliance, you're going to get hit with a huge penalty.
Okay.
Okay, and I'd like to see pictures if it comes back. I want to see the status of the property as of September 7th. So, yes,
Mr. Desiano, if there is in fact compliance, just note that there is $100 cost assessment that's due. So you could come to our office to make that payment.
Yeah.
Why is the fees because of what's the reason?
Because you were found guilty.
Mhm.
You were found guilty, and you were given
Until May
up
18th.
to- until
May 18th
May 18th
to comply.
to comply, and you did not comply. So you are in violation of the order which ordered you to pay a $100 administrative fee for being found guilty. Now, if you are now going to come into compliance, I will not assess any fines, but the costs of the proceedings that found you guilty require under the city code that you pay a $100 administrative fee. That's all she's saying. Okay, so believe me, if you had not convinced me that you apparently corrected the issue, the fines that would have accrued to date would have been into the thousands of dollars. So anyway, that's what it means. Let's move on to the next case, please.
Can I have another? I don't understand why I'm receiving a fee of $100 if you have a case number with eviction. We haven't had access to the property, and we have a report from the fire department that we have fire in the building. Why? How I can be guilty of this? As a matter of fact, I'm being really. I won the case for the eviction. So how can I do something if I don't have access to the property?
That's between you and your tenant, and the reason you were found guilty is because you didn't show up on April 4th to contest a violation. If you had shown up on April the 4th to contest a violation, I might have given you a little bit more time, but you didn't show up.
I didn't show up because I was receiving the letters that were going to the property.
Mr. Murillo, was the property owner properly served?
Yes, sir. It was posted and also was mailed to the address that is on property appraisal.
Okay, so there was service of process, but in any event, even if you have a tenant that doesn't let you in, the remedy for that is you go into court and you ask the judge for an order allowing you to go in and do the repairs. As a landlord, you have that obligation to make sure that the tenant complies with the terms of the lease. If there's no lease, you have the right to go into court and have him evicted. You should have evicted him 6 months ago, 8 months ago, 10 months ago. So,
The eviction,
you know,
if you check the eviction started a long, I don't know how many months ago, but it was a very long eviction. But it's okay.
Well, no, it's not okay because you don't seem, you seem to be blaming it on the city when it really is the tenant's responsibility to leave when they get served with an eviction. Why did it take so long?
I'm asking myself the same. I'm not. I have a lawyer, and we have a case number. Everything is.
Yeah,
I sent all the documentation needed.
I've done plenty of evictions, and a simple eviction can happen in 30 days. Most evictions can take place within a couple of months, unless you're talking about a very complicated commercial case. This is a very simple landlord-tenant lease on a single-family home. I can't envision this case taking a year to get resolved in court. So, you're blaming everybody except yourself. And so, I don't appreciate, and you don't show up at your hearing thinking that it's just going to go away or somebody's going to sweep it under the rug. No, you failed to show up at the last meeting when you could have told me about the issues you were having with your tenant, and you didn't.
We have a meeting before. We have a hearing before. I was attending the meeting and I sent all the documentation requested.
I don't know what meeting you're talking about, but
yes, we have a meeting.
When was the meeting?
Mr. Mauricio, you were in the Zoom.
I guess if I'm not mistaken, I think you gave him an extension. I think he didn't show up for the first one. I think it was he's talking about the second.
Yes. We have a Zoom.
He showed up to the second, not to the first one, if I'm not mistaken.
Okay. Whatever. My thought is that if you've already done the work and the code official says that the work has been done satisfactorily, the case is over. And we started arguing about $100 administrative fee that is owed the city because I found you guilty. And it seems like this $100 charge is getting you all bent out of shape. And it shouldn't be. It's actually a favor that I'm extending that, I'm going to give you until September 7th to convince the code officer that the work has been done properly. Something that should have been done a week ago, or 2 weeks ago, or 3 weeks ago. So since you told me that the eviction took place in July 12th, what has happened between July 12th and August 3?
We have a fire in the house.
Inside?
Inside, and the report shows, it's not myself, I'm telling you, the report says you need to call an electrician because electrician service might be compromised.
Okay, well, in any event, you fixed the problem for now, not the electrical problem, but the other problem. Anyway, that's it for this case. Let's move on to the next case.
The next item I'll be calling in is item number 46 and 47. Item number 46 is North Miami West Holdings, LLC. Case number CEFOB 2022-00347. And item number 47, case number MHVIO 2022-00338. This case was previously found guilty with an abatement date of June 15th, 2023. Fine was set at $250 plus $100 cost assessment. Gennaro Murillo is the officer.
Did you just read 46?
46 and 47.
Okay, 47 was found guilty. 46 has not been found guilty.
That is correct.
Okay, let's hear 46, business tax receipt. Let's hear from the officer.
Magistrate, before you proceed, let me go ahead and swear in Liliana Lopez.
Okay.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
All right, Mr. Murillo.
Yes, sir. So on May 11, 2022, a case was opened for the property address 771 Northeast 126th Street to apply and obtain a business tax receipt. a notice to, there was no compliance, a notice to appear was posted. I'm sorry, a notice to appear was posted on, notice to appear was posted on July 11, 2023. It was also mailed July 13, 2023. I had a final inspection July 20, and there was no compliance.
Okay, Ms. Lopez, how come there's no compliance on the BTR issue? We can't hear you. You're muted. Still can't hear you.
Can you hear me now?
Okay, now we can.
So we already have the Miami-Dade certificate of use, and the city of North Miami already has submitted the application. So I'm just waiting on them to issue that so I can also finalize the permit that I needed.
You're talking about the next item being the permit for the work done inside the house, but you're telling me that the paperwork has already been submitted on the business tax receipt?
Correct.
All right, but you don't have a business tax receipt now.
Not as of this moment. I only
Okay.
have the certificate of use in process.
Okay, I'm gonna give you some time to get the business tax receipt. Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists, that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of September 21st. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Ma'am, all that means is that you have until September 21st to get a BTR. And if you don't have a BTR by then, fines will begin to accrue at the rate of $250 a day.
Understood.
All right, so let's hear the next case, which is the one that I found the property owner guilty back in May of 2023 with an abatement date of June 15th. Let me hear from the code officer.
On May 11, 2022, this violation was open, again, for the property address 771 Northeast 126, to obtain and after the fact the permit for the work that was being done inside the property. I posted an order to comply on May 31st, 2023. On July 11, the notice to appear was posted. It was mailed on July 13. I had a final inspection on July 20, and there was no compliance.
Show me the pictures. I thought the work was done inside the property.
All of those have been closed. We're
Okay,
talking about
that's the yeah, that's what I remember. That picture I remember. Any others? Okay. What do you, ma'am? What do you mean by those permits? Those are being closed.
No, I'm sorry. I meant that the outside pictures that he was showing, that's not what we're talking about. I already submitted a permit, and I have some comments that I'm addressing. Now, I cannot pull the permit will not be issued until I have the CU and the BTR from the city of North Miami. So one thing is connected to another.
Well, you're not being cited for not having a CU. But you must complete the work, and you should have completed the work by June 15th. What is your recommendation, Mr. Murillo? Should I give him more time or assess the fines?
Give me a second. Let me check on.
If they're going through the process with the building department and they're moving along actively and in good faith, I'm inclined to tabling this until September 7th, which is my next meeting.
Okay,
But I haven't decided. I want to hear from the code officer.
understood.
Well, he's looking, Ms.
Okay,
Lopez. Are you,
so-
yeah, wait. Ms. Lopez, what is your association with the property?
I'm the owner's assistant.
This is a privately owned multifamily building?
Yes,
And who's the owner?
it's Mr. Francis Jacob.
And you have authority to speak on behalf of Mr. Jacob?
Yes, I do, sir.
Okay, next time he might want to be present. I'd like
Not
to hear
a
from him.
Okay.
Okay, Mr. Murillo, tell me what's
Okay,
going on
so
with the building department.
there has been a denial since June 17. So you might have to get in contact with the building department because
I
since
already
June
am.
17, there's not been no progress on the
Correct.
the
We had
permit.
to hire, I'm sorry to interrupt. We had to hire an engineer and architect to do the proper plans because initially we just submitted as a sketch. So they want proper plans, which are in the working.
Okay. You better work fast because I'm gonna hear this case on September 7th.
All right, sir.
And if you don't have the building permit by then, you're gonna be in trouble. Okay?
Yes.
So September 7th, I want this case back before me.
Absolutely. I'll do my
So-
best. Thank you.
Magistrate,
Okay.
I'm gonna go ahead and table it for September 7th.
Yes. All right, are we done with this property?
Yes, we are.
All right, let's move on.
Thank you.
gonna-
all.
I'm gonna call item number 63.
Okay,
Vito,
just before you call that item, this is the last item we're gonna hear before we break. We're gonna break for a 10-minute lunch, bathroom, whatever you want to call it. We're gonna have a break, 10-minute break after we hear this case.
no problem.
Okay?
All right, item number 63, Vito Marletta, case number CETRA 2022-000013. Jose Perez will be presenting this case.
Okay, Mr. Perez, why don't you tell us what this case is about? I want you to show me the pictures of the tree in question and tell me whether this is a protected tree, an invasive species, and whether more testimony is necessary from your tree expert.
Absolutely. Jose Perez, manager for the Neighborhood Services Department. Today we're hearing the case related to the property at 2039 Northeast 123rd Street. This case is as it relates to hat racking of a tree. A proactive inspection was done through the canal of the property off 123rd Street on the waterways where a tree was observed to be purposely cut. It was at that point in time where a email was sent to the city's arborist triage in reference to the manner in which the tree was cut. The arborist determined that verbatim, they are all definitely hat racking. I can't tell what kind of tree the one is on the patio. Unfortunately, or ultimately, they have to prove that it is prohibited species that is exempt from the ordinance. Or by the time I see it, maybe I will have leaves and I can tell. So at this point in time, the arborist determined that it was considered hat racking. The violation was sent to the property owner, requesting them to pretty much comply with mitigation requirements set by the city's ordinance with the Community Planning and Development Department. They were giving an initial notice of violation with reinspection date of August 19, 2022. So well over a year now since the violation. And at this point in time, the property owner has not started or began any mitigation efforts. It was at that point that the notice of violation was mailed to the property owner, and we're here for the hearing.
All right, let me ask you, I'm looking at the code 29-5-2309 tree abuse, and it has a schedule of fines based on the size of the tree. Are you Are you familiar
Correct.
with that section?
Yes, those fines
So-
will be determined by the arborist when they do mitigation, whether or not they would need to replace a tree or place funds into a tree mitigation trust.
So what is it that, assuming that you prove the case and there are no defenses, what is it that you're asking me to do?
So the city is seeking for an adjudication and a monetary fine set until mitigation has been met. The mitigation requirements would be separate from this hearing. So those monetary amounts would be determined by the Community Planning and Development Department, but the city is seeking that the property owner begins and follows through with the mitigation process.
Okay, so you're asking me to do two things, or actually, it's a two-step process. The first is for me to find the violator for tree hacking in violation of that section that I just quoted. And then the second step is the property owner is required to go through a mitigation process where, depending upon the size of the tree, based on the arborist determination, then the mitigation amount will be applied at that time separately from the fine that I impose.
Correct.
Do I understand the process correctly?
Yes, sir.
Okay, anybody here on behalf of the owner? I see a Dominic Marletta.
Yep, Dominic, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God, please say I do.
I do.
Sir, you've heard the commentary between the code officer and myself. I saw the pictures, I saw the tree. I know what the code says. What say you?
So I own the property with my father. I personally live in Virginia. I just happen to be in Florida right now. My father, 84 years old, trimmed the tree because he said it wasn't producing any more mangoes, but he did a little bit more in trimming from what I saw when he sent me the picture. The tree now is healthy. I mean, it's just revived. It wasn't, like I said, it wasn't producing mangoes. What they say, hacked the tree. Now the tree is healthy. Produced mangoes this year. So that's the only letter I got from the city is the letter back last year, which I told my father to go to the city of North Miami. He paid a $88 permit fee and then a $300 fine, which I have a copy of the checks, which was dated 8/2/2022. So I thought the issue was resolved. I was away out of town, and when I come back to my business, I saw that I had to be in court. Well, I thought it was like I was like I actually have to go to court. Didn't know it was a hearing. So that's what I know about the whole situation. I don't know anything else.
All right.
I honestly didn't even know you needed a permit to trim a tree, but he did like I said, did a little bit more than trimming. When I saw the picture.
No, you don't need a permit to trim a tree. I trim my mango trees all the time, and they survive and they give beautiful mangoes. Okay, I have 2 of them.
Okay.
Mr. Perez, was a fine already paid, or was it for something else?
I'm logging in right now to check that, but from my communications with Community Planning Development, they did not seek through with the mitigation process. If they just allow me 1 second, sorry. I don't want to speak out of turn here.
And just for reference, the check was dated 8/2/22, August 2nd, 2022.
For how much?
One was $88 that my dad said, I guess it was for a permit. And then it was $300, I guess, for the fine.
Okay, so I'm
from what my dad told me. I'm just going on what my dad told me.
Yeah, no, that's not a problem. So I'm reviewing it here. It appears that that's for an after the fact tree removal. So that was something completely separate. I guess a tree was removed as well.
I'm not really sure. Honestly, I'm not really sure, but I don't think so.
Okay, so based on the notice that I'm seeing here, it says an after the fact tree removal, and that was what you're advising of the August 2nd, 2022.
Correct.
So at this point in time, the city doesn't object granting more time. We could table this case so we could get further clarification. Mr. Dominic, if you wouldn't mind reaching out to me, we could get this resolved amicably without means of
whatever we need to do to
fines.
make it right.
Yeah, I am not considering the circumstances, I'm not ready to rule today. Certainly without the arborist telling me some things I need to hear. Again, I usually trim my mango trees during hurricane season.
Yeah,
I saw
get it.
I saw the pictures, and I have some questions. I hope the property owner and the city can resolve it and not have to bring it back. But if you have to bring it back, I'm ready to, I'll hear it. Based on the fact that, a payment was made for 300 and the tree is healthy. I don't know that I want to take action at this time. So Mr. Perez, please work with the property owner, and
Definitely.
hopefully it won't come back to me. All
Yeah,
right,
we'll
next
table
case.
this. Mr. Dominic, I'm going to drop my email in the chat directly to you. And if you kindly can, just shoot me an email when you get a chance, and then we'll go ahead and communicate directly via email.
Was it on your business card? Because I think my father sent me the business card. Your business card.
It is on my business card as well.
Okay,
Yes.
perfect. Yeah, so I got a picture of that, so I got it.
All right. Thank you. Have a good day.
Thank you, sir. You too. Bye-bye. What a big deal. 4 hours, my gosh. Now,
You need to. All right. Next case.
The next case I'll be calling is item number 57 and 58, Pride Properties LLC.
Oh, I said we were going to take a
Well, we have
brief
two
10
more
10
attendees. Can
Oh,
we knock them out and then?
All right, then we'll take a break.
Yes, sorry.
All right. Yeah, I don't want to keep people waiting if they've been waiting. Let's do those two, and then we'll take a 10-minute break.
Perfect. We have Pride Properties LLC, case number for item number 57, CEBPR 2022-00660, and item number 58, case number CEBPR 2022-00661. Shanna Sanders is the officer.
All right, we haven't heard from her today. It seems like Jose and Murillo have monopolized the entire operation here. But Shanna, nice to see you. Tell me about 57, 58. It looks like expired mechanical permits on the same property. Two separate violations?
Two separate violations. One, Shanna Sanders, Neighborhood Service Inspector, my apologies. Yes, these are two separate violations for expired building and if not mechanical permits that were obtained. I'm looking at this, at the history of it, and I believe the attorney called me earlier. We had a slight conversation while Gennaro and Jose was monopolizing the hearing, and he brought to my attention he had submitted a permit to the building department for the mechanical permit. So I'm trying to look here. I'm not sure if he's logged on to the hearing. Because I'm going to ask for these cases to be tabled. He stated that he already spoke to the building department. He specifically stated Gary Beswick told him that the permits are ready. All he needs to do is pick them up. So if he wants to chime in and confirm when these permits are going to be picked up and the old ones closed out, I'm more than willing to table these cases, if not close them, as soon as that current mechanical permit is ready.
Yeah, if the permits have been already issued, you don't need to bring it back. You can just close the file. Mr. Shepherd, are you here on behalf of PRI Properties?
Correct, although technically I work for the tenant on the property.
Okay,
But yes,
so
we're appearing on behalf of this. Do I need to be sworn?
if you have not been sworn, you need to be sworn.
I have not been sworn yet.
Okay.
Are you an attorney, sir?
I am an attorney. I'm the in-house attorney for the tenant. Yes, ma'am.
Okay,
So
then you don't have to be sworn.
Okay, fair enough.
Okay, we
So-
we have something called Florida Bar Rules of Professional Professional Regulation, I think it's called. So that's the hammer. Anyway, what is the position of the tenant or the property owner?
Yes, we had previously submitted the permit application after the last hearing. Obviously, there's back and forth with that. We were notified on July 31st by Mr. Beswick that he had just approved the permit. The contractor went to pick it up. already, and unfortunately needed to update their insurance information, which they did with the city. So we should be able to pick up that permit as early as today. Obviously, we will do that and then proceed with the work, and the other permits will allow us to be closed out. So we
What
should be.
is the issue with mechanical? What mechanical component of the property is in question?
So one of the old permits was for duct work, and the other one, as I understand it, was for HVAC work that was done. That work was actually done back in 2012 and 2013. Unfortunately, the contractor that was used back then did not properly submit that for inspection and closeout. So we actually are going ahead, and the duct work doesn't need to be repaired, but I believe we're going ahead and replacing the HVAC units anyway at this point in time. So that's what the new permit, which is BME 2023-93, is designed to do.
All right, and you're speaking on behalf of the tenant?
Yes, the tenant. It's a Taco Bell restaurant.
It's a Taco Bell, and so you're not the property owner, you're the tenant, and it's your responsibility under the lease to undertake these repairs and corrections.
Absolutely.
Who's Nick Davis? Is he the manager?
Nick Davis, I believe, is one of the individual owners of PRI Properties.
Okay, and I see that he's out there in Gainesville.
Yes, I believe they are located in Gainesville. I'm actually in Clearwater.
Okay. All right, thank you for advising us. I will table the case until the city has an opportunity to determine whether or not the permits have been closed. And so if they have been closed, then there's no need to come back. If they remain open, then I'll hear it at the next meeting.
Great, appreciate your
Thank you.
courtesies. Thank you very much.
Okay, thank you. And as I said before, we'll take a 10-minute break.
Well, we still have one more.
Oh, you had one more? I thought these two were the last ones.
No, we have Hassan Moskani. I've been trying to communicate with you in the chat to see which case you are here on behalf. Please enable your camera and audio. Hassan Moskani.
There he is.
I'm gonna ask you to unmute yourself.
We can't hear you. There's a little button on the bottom.
Yes, I got it.
Okay.
What case are you here on behalf, sir?
Actually, the property is 770 Condominium Association, which is the address is 770 Northeast 128th Street. And I believe Mr. Perez is available.
Yes, I have it. It is magistrate. It is item number 15,
15, sorry.
15 through 21.
Oh.
Item, yeah. Do you want me to read each one of them? Or as the officer is testifying, you want me to call them one by one?
Yeah, maybe.
Why don't you read all 15, get it out of the way, 15 through 21, read them all, and then
Sure.
we'll deal with them one at a time.
No problem. Item number 15, 770 Condominium Association. Case number for item number 15, MHVIO 2022-00340. Case previously found guilty with an abatement date of May 18, 2023. Fine was set at $150 plus $100 cost assessment. This case is in compliance. Item number 16.
Wait a second. I can disregard case 15?
Yes.
All right, we're done with 15. Okay, let's do 16.
Item number 16, 770 Condominium Association, case number MHVIO 2022-00341. previously found guilty with an abatement date of May 18th, 2023. Fine was set at $500 plus $100 cost assessment. Item number 17, case number Image VIO 2022000352, previously found guilty with an abatement date of May 18th, 2023. Fine set at $250 plus $100 cost assessment. Item number 18, case number Image VIO 2022000353, previously found guilty with an abatement date of May 18, 2023. Fine was set at $750 plus $100 cost assessment. Item number 19, case number Image VIO 2022000354, previously found guilty with an abatement date of May 18, 2023. Fine set at $350 plus $100 cost assessment. Item number 20, case number Image VIO 2022000356, previously found guilty with an abatement date of May 18, 2023. Fine set at $500 plus $100 cost assessment. And item number 21, case number Image VIO 2022000359, previously found guilty with an abatement date of May 18, 2023. Fine set at $150 plus $100 cost assessment. This case is also in compliance. However, cost assessment is due.
And that was
21.
21.
Yes, so 21 and item number 15, they are in compliance, but however, cost assessment is due.
All right.
Item number
Wait,
19
wait.
is also in compliance. My apologies.
Which one?
Item number 19, the exterior conditions of the building.
Yes, it's in-
19 is in compliance.
Yes.
Okay,
Those
so let's,
dates.
what are we, we're going to 16 then?
Yes.
Mhm.
All right, let's hear 16. Missing railing on the stairway.
Jose, before you begin, Mr. Hassan, can you please
Yes.
raise your right hand? Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Jose Perez, manager for the Neighborhood Services Department. We're hearing the case as it relates to the property at 770 Northeast 128th Street. The first case, number 16, as it relates to the missing railings on the stairwell leading to the second floor on the west side of the property. Unfortunately, this is a safety issue. And unfortunately, as of the final reinspection date, the missing railing is still not replaced. I know the HOA president, Mr. Hassan, has been in communication with me as it relates to having these repairs made. So they're in the process of it. So at this time, unfortunately, they have not been rectified. I'll let Mr. Hassan speak to what the status is on that.
Yeah,
Yes.
Mr.
Mushkan.
Mushkan?
Mushkani.
Mushkani, okay. Of all the violations, to me, this is the most serious.
Of course.
Because a child can go right through those railings and kill himself, and I've seen it happen. It's not hypothetical, it's not theoretical. First of all, tell me who you are, who do you represent, what is your involvement with the property, and why are you not yet in compliance with the violation here under number 16, which has to do with a missing railing?
Okay. The building has a 15 apartment.
No,
which is-
first tell me what your relationship. I heard you're the HOA president.
Yes, my name is Hassan Mushkani.
So these are
I am-
these are condominiums.
Yes, this is condominium. I'm not the president. Actually, we never had the association in the building, which is on last hearing was on June 1st, which is I show up myself again. And unfortunately, none of the owner get responsible to show up and do something. I have just only one apartment in the building from 15. And I'm trying to do my best to see in my part any problem to get resolved. But I haven't get any owners involved with this one, which is one of them recently get involved with the association. We active the association again. I'm in process of with the the person who got involved, he's the president of the association. And
Do
he's
you,
not
do
showing
you,
up.
do you know, sir, that there is no association, that it's been dissolved by the state of Florida?
Yeah, it was, but we activate the association again and processing to get a management company for the property. So
Well, how do you operate if there is no association?
actually, it was very, very difficult, this is maybe the 10 times I have show up myself at the court to resolve any problem with the building. But I don't get anything for that one. I do from my heart, and then just doing for free in the building. But even today, I text everyone in the building. We have a hearing at 9:30, and no one even replied to my text. So anyway, on August 9th, we have a meeting at the property, and there is a letters on the board right now, and we send owners. They have to show up at that day to remaining the violation of the building. So already we had like 9 violations, which is I believe 5 or 6 of them has been solved. So which is pressure clinic and cleaning the building, and the electrical, the exit light was fixed. So the remaining, I believe, is just the railing, which is on the 2nd floor. We contact with a few contractors to get the estimate. They couldn't find the piece similar, the same existing railing to put it on the place. But still they are looking, and hopefully in next few weeks, hopefully they find it and place it the same shape, the same design to repair it. But anyway, on August 9, we have a meeting, which is hopefully in this meeting, because it has been certified letter to all the owners, and even the appointed association, the appointed the management company, they are to the meeting, and hopefully we hire the management company, and all the other owners, they will show up. Thing. So most of the violation correct. Only missing railing and 4 window screen is missing, which is I text to the owners. They need to put the screen back to get pictures, send it to Mr.
Yeah, we'll get to the
violation.
screen, sir. We'll get to the screening issue in a minute. We're talking about that railing.
Okay.
We're talking about that railing, and that scares the hell out of me.
Yeah, this is the 2nd floor, is not the other floor. The building has 3 stories, 2nd floor. But I contact with the contractor, they haven't find the same type of railing. So if it's not, they said they need more time, which is about discuss with to figure it out, to do something with this railing, but they haven't find exactly the same one to do that. If it's not, they have to do something else. So I am waiting today, the day of meeting, which is on August 9, to see if anybody, other owner, they show up, they have any idea of how we can fix it, and then we go after that one. Definitely, we are going to fix it. It needs to get fixed.
Yeah, well, I'm not convinced that you've acted quickly enough based on the circumstances and the potential life safety component. At least in the meantime, you could have put a board there or some other screening to keep someone like a 3-year-old from falling through. So I am going to ratify the prior order based on the testimony of the city's code compliance officer and the photographs that I have seen, showing that that the association, which doesn't exist, I don't know what they are, but to the extent the property owner is in control, the property is in control of various people, although there is no association. I find that the property has been out of compliance since Magistrate Kazoo entered an order in April of 2023 with an abatement date of May 18th of 2023 and set a $500 fine, which is a high fine considering what, what we have. I hereby ratify the fines accrued to date in the appropriate amounts based on a $500 assessment of fine and assess costs in favor of the city. The fines shall continue to run on a daily basis until there is compliance. What this means, sir, for all the owners in this development, this project, is that for every day since May of 18th, there will be a fine going forward of $500 a day because of your failure to comply with this order. And I see no effort here from what I'm hearing, I see no effort to make this condition safe, and I find this to be a life safety issue. So you let your unit owners there know that they're going to be assessed a very heavy fine for their negligence and for their inaction and allowing the association to dissolve itself. This is not the way that we do business in Miami-Dade County. So that's all I can say about case number 16. Case number 17.
I have a question regarding actually the railing.
Yes.
On June, I think June 1st was the day, I believe it was the last hearing. I came actually to the building, to the court through Zoom. I did it from the first floor. So that day, the day before, I found this document. I never seen that one before, which is I explained last time. This is the first time I have seen that one. One of the owners, he brought me this pages, he gave it to me. And then when I talked, even Mr. Chris, he came down, we talked about it, I explained, this is the first time I have seen this actually violation. And that was the day actually I was aware of that one. So since that, I am working. I said that we had the kind of, the violation was 9 violation, which is 5 of them up to date has been solved. The remaining, actually, there is another one would be tomorrow, which is the contractor is going to do the other violation is going to fix it in the property related to the actually parking area. Is going to work on it and fix it definitely tomorrow. But I need maybe more timing. Definitely all of them would be resolved. I'm going to actually always I'm going to communicate with Mr. Perez, and he knows about it. Anything I have it, I text him, I send him a picture. So the railing is, I know it's very important. I didn't know I could put maybe a rope or something to cover it up. I didn't know until this moment. I can do it today to keep it safe.
First of all, the orders were entered by Magistrate Casu in April. I have no record of anything happening in June. There's an abatement date of May 18th, which means that you had until between April 6th and May 18th to fix these things. And you, of course, you chose to do the easy things first, like a lighting, changing a light bulb. That's not gonna do it when it comes to this violation. Okay, it's very easy to change a light bulb. It's more difficult to do a railing. So if you want the fines to stop, you better work with the either the building official or the code officer to correct that railing, even if you have to put a railing that doesn't fit the aesthetics or maybe some other protective device. Otherwise, you're earning, I would say, a fine of $500 per day until the violation is cured. So if you want to go out there tomorrow with a code officer and show him that, on an emergency temporary basis, you took care of that railing, maybe we will forgive some of those fines. But otherwise, it's going to cost you.
Of course, it's no problem. I can be
Okay.
at the building tomorrow.
You
Mr.
should
Perez.
be out there tomorrow with some contractor to put some kind of a railing in there and stop the fines from running. And as soon as you do that, you call the code officer, Mr. Perez, he'll go out there and find whether or not this is acceptable.
Okay.
Okay? And then you can go to the city manager and maybe the city manager will have some, be more lenient. But I can't let this violation go unpunished.
Thank you.
Okay? The last one is the missing screens. I've seen the pictures. What's the problem there? How come you can't get screens to cover these
Yeah,
windows?
there is a 4-screen window screen is missing in the building, as far as I am aware of that one, which is I send the picture, I send the violation note from the city to the owners. They are going to do that. I think maybe actually yesterday I heard one of them, they already put the screen back. So this is, and the remaining, they said they are going to do it. So tomorrow I'm going to figure it out. So they finish it or not yet?
Okay, so, but today I'm going to ratify the fines because it's not difficult to get screens to put on a window.
Correct.
And we don't want cockroaches, bugs, even birds flying into an apartment because it has no screen on, mosquitoes, etc. So based on the testimony of the city's code compliance officer, the photographs and evidence presented depicting that the property has been out of compliance since May 18th, 2023, and we're talking about item 17, which is missing screens. I find in favor of the city. I ratify the fines accrued to date in the amount of $250 and assess costs in favor of the city. The said fine shall continue to run on a daily basis until there is compliance.
Their windows always close. Actually, when I communicate with the owners, the owners individual, I told them why you remove the window. They clean it up, never put the screen back, they said. But their windows are closed. Just missing the small, there is a small windows.
Does it matter, Mr. Perez, whether the windows remain closed or not?
It does not, per the ordinance, screens are required, unfortunately.
That's what I thought. That's what I thought. All right, so those are my rulings. It's good that you started paying attention and fixing some things, but you still have 2 critical items that you need to fix.
Of course.
And I would advise the owner that it's time to do it. Okay?
Thank
you. So at this time, because some of us really need to take a break, let's take a 10-minute break and we'll see you.
We have 2 more for this property. Sorry, number 18 and number 20.
Boy, you're really gonna kill me. 18 and 20,
Yes,
same property?
same property, 18 and 20. One is for the elevators. I believe Mr. Hassan is mentioning that he is in the process of getting them repaired as well. And then number 20 is for the parking lot, several potholes that need to be filled in and resurfacing and restriping.
Okay, the elevator is not working, right?
The elevator is in active, status.
It's approved.
It's approved by City of North Miami.
Well, the city of North Miami wouldn't approve it. It'd be Miami-Dade County.
It is approved in an active status. We had a building official actually.
Does the elevator work?
No, it doesn't work. This is actually years ago. We got the letter. We got the inspection from building official. The City of North Miami, they came, and because of the 2 ways railing to the other floor, they said it can be. We got the letter from all the owners at that time. City of North Miami building official approved to be in active status.
Yeah, but as Mr. Perez is telling you, the county has not approved it and has not given you a certificate, right?
I talked to Mr. Ortiz. which is Dade County's elevator, I think, official. I communicated with him at that time. And he mentioned as long as the city of North Miami, they approve it, it's okay with him.
What do you say, Jose?
We
I
can
can show
table
him the
this.
letter tomorrow if you want to.
Yeah,
We could table this one. That's fine.
Yeah, I'm not convinced. If the elevator is broken, you cannot be in compliance, okay? Whether it's the county, the city, or the US government. If the elevator doesn't work, you're out of compliance because people that are disabled need to use that elevator to go up to their units, number one. Number two, if you have an elevator, it needs a county certificate, okay? And you are not telling me that you have a county certificate. The county is the one that regulates elevators. And so, yes, Jose, table it, but I think that what they're gonna have to do is fix that elevator. And I don't believe that they're gonna have any money to do it because fixing an elevator these days can cost you as much as $60,000. And I don't think they have the money to fix it. So we're gonna be back here a month or 2 months from now, we're gonna be arguing the same issue. So I don't know how you're gonna be able to work that out. How many floors is this building?
Three floors, and then the two ways has a stairwell.
Okay, so how does a person in a wheelchair get up to the third floor?
So there is I believe the owners, they try to rent to the tenant because most of this apartment has a tenant. There is only one owner lives there, so it's good, but try to give it to someone which doesn't need the elevator, probably. I don't know.
Okay, Mr. Perez, can you look at that as well, the disability requirements, and see if they're in violation of that as well?
Per floor statute, anything that's 3 floors or under, it's not required to have an elevator. So they'd be in compliance with that aspect. But Mr. Hassan, forward me that letter you mentioned that you have when you get a chance. We'll mention that we'll table this case as mentioned, and as a means of expedite, I know Magistrate Smith wants to go to recess. Let's go ahead and go into number 20, the final case here for the parking lot.
Oh, yeah.
All right, so the parking lot needs some pressure washing.
Several holes need to be filled in, and it should be restrapped and resurfaced.
This is number 20?
Yes, number 20.
Okay, potholes.
Yes.
It doesn't take that much work to fix the potholes and resurface and restripe the parking lot. What's the issue there?
We have a contract tomorrow. The contractor is coming, he says tomorrow morning to fix it, repair it wherever it needs to do that. Tomorrow they'll be there.
Okay.
And then I explained actually to Mr. Perez regarding that.
Okay, it seems like you're gonna be very busy tomorrow.
Yeah.
Since we tabled the last item, we're gonna table this one as well, and we're gonna see what is happening with the potholes. I want those fixed by my next meeting, or you're gonna get cited. You're gonna have to pay fines. And apparently, the prior magistrate imposed a $500 fine per day if you don't comply. So first thing I would do tonight is let everybody know that we're gonna stop playing games and that people are gonna have to come out of pocket with assessments and what have you, or the building official is gonna have to shut down the building, issue a red tag, and evict everybody, because these are conditions that represent life safety. These potholes not only can affect pedestrians, they can also damage automobiles and tires. So so we're dealing with serious issues, and if your owners do not understand that, when they get evicted, they are going to have a fit, but they had it coming. Okay, so now they know. Okay. Any more cases?
Good to go. Thank you.
All right, let's see you in 10 minutes.
No problem. And the interpreters, You guys are dismissed. Thank you.
Thank you.
Okay, welcome back. Let's hear the next case on the calendar.
Next case I'll be calling, as a matter of fact, just let the record reflect, there's no more attendees in the queue. So it'll just be the officers and us. So item number 5, case number property 13055 Northeast 6th Avenue, case number CEZCU 2022-00683, Jonathan Lemestre.
The new case, I want to hear from Jonathan Lemestre.
Yes, sir. Good afternoon, Magistrate Smith. Jonathan Lemestre, Neighborhood Service Inspector. On August 22nd, 2022, I opened a notice of violation at 13055 Northeast 6th Avenue in regard to no certificate of use. I posted the property with the notice of violation. I also mailed the notice of violation to the property owner via property appraiser. As of the final reinspection date, compliance has not been met.
What kind of business is it?
It's a multifamily. It's a multifamily.
Is it are there tenants, condo owners?
No, it's a rental. It's apartment complex.
Okay, and I'm showing Elvis Dumerville as the manager of the property, I guess. Have you had any contact with the property owner?
Absolutely. So Prestige Estates, I attempted to contact them. Well, I did contact them. And again, I advised them of the situation. And again, no compliance.
Okay, based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the violation still exists and the proper notice has been given, I find in favor of the city enter an adjudication and set a compliance date of September 21. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Thank you.
Next case.
Item number 6, 1525 Northeast 125th Street, Prestige Point. Case number CEZCU 2022-00353. This case was previously found guilty with an abatement date of January 12, 2023. Fine was set at $250 plus $100 cost assessment. Shanna Sanders.
Okay, Ms. Sanders, anything new that I need to hear?
Shanna Sanders, Neighborhood Service Inspector. No, nothing new. This is a case for coming back for non-compliance. Again, as of the reinspection date, compliance has not been met. They have yet to obtain their certificate of use or apply for the certificate of use. I am showing proper service was given. The notice to appear was posted at the property on July 11, 2023. Also certified mailing was mailed out by our administrative staff. And again, no compliance has been met.
Okay. Based on the unrebutted testimony of the city's code compliance officer and the evidence presented, depicting that the cited violations still exist and that proper notice has been, no, wait a second, you want me to ratify the fines because Judge Gazelle has already found them guilty, correct?
That's correct. This is another Prestige property as well. And yes, we're just asking for the fines to go into effect.
Okay, based on the unrebutted testimony of the city's code compliance officer and the evidence presented showing that the property has been out of compliance since January 12, 2023, I hereby find in favor of the city, ratify the fines accrued to date in the amount of $250 plus a $100 cost assessment. The fine shall continue to run on a daily basis until there is compliance.
Item number 7 through 11. 400 Northeast 137th Street, Prestige Vista. Case number for item number 7 is CEMHS 2022-00531. Item number 8, case number CEMHS 2022-00532. Item number 9, case number CEMHS 2022-00533. Item number 10, case number CEMHS 2022-00535. And item number 11, case number CEMHS 2022-00536. Christopher Colson.
Colson.
Good afternoon, Your Honor. Do you want me to read them all at one time and rule?
No, let's do number 7. Number 7 is a business tax receipt issue.
Okay, here we go. Officer Christopher Colson, North Miami, City of North Miami, Neighborhood Service Department. This is a new case. CEMHS 2022-00531. This is for a business tax receipt. The violation was originally opened on 8/31/2022. Notice was properly given. Did a recheck. No, nothing had been done at that time. As a final reinspection on 7/26/2023. Still no compliance. I have had verbal contact because I went by the office. Still nothing has been done and notice was given.
Who did you give notice to?
I gave notice to the property, the Prestige, and I went to the office and I spoke with one of the managers one day, just like y'all have court cases coming up and y'all have not talked to me, reached out to me, have not complied with the court cases. And
okay, I've seen GP19 Management or Prestige Estates.
Yes,
Las Olas Boulevard. They're all in Las Olas Boulevard.
Yeah, that's one of them. That's where they locate Lolas, but they have another local office that's right up the street from our office here.
Okay, so they know about this.
Yes, they know about this. Another one of Prestige properties that you
Okay.
just heard about.
Based on the unrebutted testimony of the city's code compliance officer, the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city. Enter an adjudication and set a compliance date of September 21. In the event of non-compliance, there will be a daily fine of $250 until the violation is abated.
Next case is CEMHS 2022-00532. That case was also open on 8/31/2022. Violation was filed for certificate of usage and proper notice was given, mailed out. Like I said, in the previous case, I went by the office, talked with the people in the office, and as a final reinspection on 7/26/23, violation still remains.
This is a certificate of use. Do you have any idea why they have not obtained a certificate of use?
I do not have an idea why. I could say this is a pattern with some of Prestige's properties because I've had several of them, and that's a pattern with them.
Okay. Yeah, I see the name quite a bit in these proceedings. So based on the unrebutted testimony of the city's code compliance officer, the evidence presented depicting that the violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Next case, CEMHS 2022-00533. This is a new case as well. This is for the Prestige Apartments. Violation was open on 8/31/2022 for extermination report. As of 7/26 on the final reinspection, I still have yet to receive the email or anything in the mail as I have yet to receive an extermination report from the property.
All right, based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Next case, CEMHS 2022-00533, another new case involving Prestige Apartments. It's for a mailbox in disrepair and broken. Proper notice was given. Violation was open on 8/31/2022. As a final reinspection on 7/26/2023, mailboxes still have not been repaired. No compliance.
Based on the unrebutted testimony of the city's code compliance officer, the photographs that I've reviewed and the evidence presented depicting that the cited violations still exist, the proper notice has been given. I find in favor of the city enter an adjudication and set a compliance date of September 21st, 2023. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Last case out of all of them, CEMHS 2022-00536, another new case involving Prestige Apartments. 9/8, the case was open on 8/31/2022. Violation was found. The violations for abandoned vehicles on property and derelict vehicles. As a final reinspection, we still have several abandoned and derelict vehicles on the property. No compliance.
Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violations still exist, proper notice has been given. I find in favor of the city enter adjudication and set a compliance date of September 21. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Magistrate, you said $500?
I said 500. This is a more serious violation. I've seen the number of vehicles, some of them wrecked on the property, and it's a more serious violation than the others.
No problem. I'm gonna call item number 12 and 13, 575 Northeast 127th Street LLC. Case number for item number 12, CESOD 2022-00013. And item number 13, case number CESWR 2022-00001. Shannon Sanders will be presenting this case.
Ms. Sanders?
Shannon Sanders, Neighborhood Service Inspector, presenting for property address 575 Northeast 127th Street. The first violation is for the siding, if not non-siding of the property. I initially cited and observed this violation on 7/15/2022, whereas I received a phone call regarding the overall conditions of the property. While doing my inspection, I observed and spoke with a young lady who was residing at the property at that time, explained to her what the violations were. I observed the front swell of the property that clearly was missing a lot of grass. It was a lot of dirt and things of that nature. She said that she would press the notice on to the property owner. I have not at this time had a conversation with anyone other than the tenant of this property. However, the violation still remains. Upon my last couple of inspection at the property, it appears now that the property is vacant. The windows, doors, everything is all boarded up. But the sides, front swell still needs to remain. The front swell still remains in need of sodding. I am showing
Would they need a permit for that?
it's a residential home, so no, they don't. The only thing they would need a permit for is if they're going to start putting landscaping rocks, if they're going to put maybe some small trees, and not so much as even a permit, just approval from zoning to make sure that if it's just grass, they don't need it, but it depends upon what they decide to put out there, if what else they would need to do.
All right. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violations still exist and that proper notice has been given, I find in favor of the city enter an adjudication and set a compliance date of September 21. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. I saw the pictures. It looks horrible. This is very visible from the outside. And so that's why I'm imposing a higher fine here than I have in some of the other cases. It's just a matter of degree. This is more serious than some of the others. Okay, let's move on to the next one. It's the same property. I believe I've seen the pictures as well. Ms. Sanders?
Yes, Shannon Sanders, City of Miami Neighborhood Service Inspector, same property address 575 Northeast 127th Street. This one is for the sidewalk and or walkway that needs to be properly repaired. Upon doing my inspections after receiving a phone call, same day, July 15, 2022, visited the property, spoke with the tenant. We spoke of the overall condition of the property, spoke of the cracks and stuff along the sidewalk. She explained she would pass that message in the notice over to the property owner. This present time, I have not spoke with anyone at the property other than the tenant. My last reinspection on July 24th, the property still remains in the same condition. Cracks needs to be, well, the overall walkway needs to be maintained, repoured, pavers need to be removed, whatever the property owner decides to do. I am showing that proper service was given. The notice to appear was posted at the property on the 10th of July. Certified mailing was also mailed out by our administrative staff.
All right, I saw pictures of a walkway within the property itself. You're not citing them for public sidewalk violations, are you?
No, this sidewalk is along the it's in the private property.
Yeah, that's what I thought. So it's not the city sidewalk, it's a walkway that leads into the front door.
That's correct.
Right, and all the pieces are broken and sitting in a very
uncomfortable, very
uncomfortable.
unsafe. Yeah, it's not leveled off. It needs some repair and replacement.
Yeah, I agree. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists and the proper notice has been given, I find in favor of the city enter an adjudication and set a compliance date of September 21. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Again, the violation here is open and obvious to the neighborhood, and it's also dangerous. If someone were to walk over it, it's a trip hazard. So that's why the fine is higher. Next case.
Item number 14, 690 Northeast 133rd Street LLC, case number CEBPR 2022-00681. This case was previously found guilty with an abatement date of July 20th, 2023. Fine was set at $250 plus $100 cost assessment. Gennaro Murillo.
Gennaro, tell me about what the status is of this violation.
Yes, I'm sorry, this is item number 14.
Yes. It's a dumpster and it lacks the permit. It needs an after the fact permit. It's a multi-family building and
yes, Your Honor.
Yeah, and it was previously found guilty by a magistrate Gazoo on June 1.
So yes, this property, the violation was open on September 12, 2022. For the property address 690 Northeast 133rd Street for after the fact permit for the new dumpster enclosure. In order to comply was posted on June 17, 2023. July 9, 2023, the notice to appear was posted and also was mailed on July 13. I had a final inspection on July 20, 2023, and no application have been made.
Okay. Based on the unrebutted testimony of the city's code enforcement officer, the photographs and other evidence presented showing that the property has been out of compliance since July 20th, 2023. I find in favor of the city and hereby ratify the fines accrued to date in the amount of $250 per day.
It's not here.
And assess costs in favor of the city. The said fine shall continue to run on a daily basis until there's compliance. Next.
Item number 24 and 25, Andy Per De Lewis, Case number for item number 24, CEMHE 20220035. This case was previously found guilty with an abatement date of July 20th, 2023. Fine was set at $150 plus $100 cost assessment. And item number 25, case number CEMHS 2022000419. It was also previously found guilty with an abatement date of July 20th, 2023. Fine was set at $150 plus $100 cost assessment. Shanna Sanders.
Shanna Sanders, Neighborhood Service Inspector, for 780 Northeast 127th Street. Compliance has not been met, as of my last, sorry, compliance has not been met as of my last reinspection. For neither case, for the extermination report case being CEMHE 2022-00035, I am showing proper service was given. I posted the property with a notice to appear. With a notice to appear on July 10th of 2023. Certified mailing was also mailed out by administrative staff on the 14th. I even had a conversation with the property owner at the time when I went to when I went to post the notice to appear. He stated at that time he had a little rough situation going on. He had been robbed. The place had been broken into the night before, but he said that he was handled it. Again, upon my last reinspection, the extermination report has not been provided at that time. I can go ahead and move on to the next case if you want to hear them together.
No, I want to hear them separately.
Okay, for that, so that's in for.
Let me rule on number 24.
Okay.
Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the property has been out of compliance since the abatement date of July 20th, I find in favor of the city. Hereby ratify the fines accrued to date in the amount of $150 and assess costs in favor of the city. The fine shall continue to run on a daily basis until there is compliance. Let me hear now number 25. I'd like you, as you go over 25, that you put on the screen the order that was entered by Judge Cazaux on whenever that, I guess June 1. I believe, or thereabouts, if you could find that. And then as you going through that, you can go ahead and explain what this case is about.
Okay, as you see here on the order, as you
stop right there. Stop right there. Okay, go ahead.
Shanna's,
just leave that on the screen and let's discuss it.
okay, let me look at this now. Shanna Sanders, Neighborhood Service Inspector. This is reference for property address 780 Northeast 127th Street for reports of non-compliance. I re-inspected the property last month. Let me just make sure. Threw me off for saying let's look at it. Now I'm thinking there's something on here.
You cited the wrong code section.
Okay, on for 5, what I got, 530? Oh,
You said 530, it should be
518. Okay, 518, yeah. So honestly, we don't have to hear this case if we can. I would, of course, I can't ask for it to be, for fine to be ratified if it was wrongly cited, especially by the city. So this one, I would ask us to, table it, and if not, I will close it and recite them under the correct code section.
Well, whatever you think you ought to do, but as you can tell, that's the wrong section to cite him under. It should be 5-18C. Okay, so I see that order to comply as defective. So what I'm going to do is set aside that order, and you can either bring it back, or I can I'd rather you set that order aside and bring it back under the rights code section. Make it clear so that we're not challenged.
Yeah, we could do that. We could definitely do that.
It's really not a life safety issue. It's not something that needs to happen today. It's simply an identification notice to be placed on the property with the name of the owner or agent. So I think we can close this case and reopen it, and then I'll hear it.
Okay.
Okay?
I'm cool. Yes, yes, definitely.
All right, let's move on to the next one.
I know that. You're on mute.
Item number 32, Buona Vista A1 LLC, case number CEOSV 2023-00091, Gennaro Murillo.
Mr. Murillo,
Yes, sir.
new case.
Yes, sir. New case. This case was opened on June 29, 2023. To the property address 540 Northeast 123rd Street. There was sent a notice to refrain from allowing any and all oversized vehicle to be stored at the property. We also asked them to secure the lot to prevent the parking of vehicles, but there was no compliance. A notice to appear was mailed on 7/13/2023. I had a final inspection on July 20, 2023, and there was no compliance. So, Your Honor, at this time, the city is asking, is seeking for adjudication to prevent future occurrences at the property.
This is a single family home or a
No,
multifamily?
this is a vacant lot.
It's a vacant lot, okay. Oh, I remember seeing that big trailer in the file. There's a huge trailer, right?
Yep.
Yes, sir.
Right, okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violations still exist, the proper notice has been given. I find in favor of the city to enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. We've heard number 33. What are we up to now?
34.
Okay,
Item number 34 and 35, Invest and Conquer International LLC, case number CEBPR 2022-00568. This case was previously found guilty with an abatement date of June 15th, 2023. Fine was set at $250 plus $100 cost assessment. And as for item number 35, case number CEFAW 2022-00063. This case was also previously found guilty with an abatement date of July 20th, 2023. Fine set at $250 plus $100 cost assessment.
Mr.
Gennaro
Murillo,
Murillo.
let's hear number 34 first.
34. This case was opened on June 8, 2022 to the property address 13900 Northeast 11th Ave to obtain a building permit for the new fence that was built at the property. Also, an order to comply was posted on May 1st, 2023. A notice to appear was posted on July 9. It was also mailed on July 13. On July 20, 2023. There's still no compliance.
Okay, based on the unrebutted testimony of the city's code compliance officer, the photographs and other evidence presented that the property has been out of compliance Since June 15, 2023, I find in favor of the city and hereby ratify the fines accrued to date in the sum of $250 per day plus $100 cost assessment. And also I assess costs in favor of the city. The said fine shall continue to run on a daily basis until there is compliance. Next case, 35.
35. This case was opened on June 8, 2022. Same property, 13900 Northeast 11th Ave. The violation notice was open to please repair and replace or remove the damaged chain link fence. An order to comply was posted on May 1st, 2023. On July 9, 2023, the notice to appear was posted. July 13, the notice to appear was mailed, and as of July 20, 2023, I had a final inspection, and the chain link fence remains damaged.
Based on the unrebutted testimony of the city's code compliance officer, the photographs and other evidence presented, reflecting that the property has been out of compliance since July 20th, 2023. I hereby fine in favor of the city and ratify the fines accrued to date in the amount of $250. This is the chain link fence, right?
Yes, Your Honor.
Okay. Ratify the fines accrued to date in the amount of $250 plus $100 cost assessment. It says cost in favor of the city. The said fine shall continue to run on a daily basis until there is compliance.
Item number 37 through 39. Joanne Gonzalez and H. Jose L. Case number for item number 37, CEBPR 2022-00635. Item number 38, case number CERCV 2022-00286. And item number 39, case number CERCV 2022-00287. Gennaro Murillo.
These are all new cases, right?
You're muted.
What?
Yes, sir. They're all new.
Oh, they're all new. Okay, let's start with
Item 37.
37. Yeah.
Yes, on August 5th, 2022, a violation was open to the property address 14015 Northeast 11th Ave. So obtaining the fact building permit for the white fence that was installed at the front of the property. I had an inspection on August 23, 2022. There was no compliance. A notice to appear was posted on July 10, 2023. July 13, 2023, the notice to appear was mailed. I had a final inspection on July 20, 2023, and there is still no compliance.
Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. One 38.
38. On August 5th, 2022, a violation was observed at the property 14015 Northeast 11th Ave to remove a bolt that was stored on the front of the property or to attain a variance. I had an inspection on August 23, 2022. There was no compliance. A notice to appear was posted on July 10, 2023. On July 13, the notice to appear was mailed. And as on July 20, 2023, the bolt remains on the property and they haven't applied for a variance.
Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
on 39. Yes, on August 5th, 2022. The case was open to the property address 14015 North 18 Evan Ave. It was asked to remove the trailer that I was storing in the front of the property or to apply for a variance. I had an inspection on August 23, 2022. There was no compliance. The notice to appear was posted on July 10, 2023. It was mailed on July 13, 2023, and I had a final inspection on July 20, 2023. The trailer remains on the property and they haven't applied for a variance.
All right, so I'm clear. The trailer is separate from the boat.
From the boat,
The boat
yes.
the boat is not on top of the trailer.
There is a boat on top of the trailer and there is a trailer.
So there's a separate trailer.
There's a separate trailer.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, the proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Item number 40, Keystone Manor Condominium Association, case number MHVIO 2022-00490. This case was previously found guilty with an abatement date of July 20th, 2023. Fine was set at $250 plus $100 cost assessment. Jose Perez was the officer, and I believe we have somebody in the queue by the name of Belkis Mirabel who logged in last minute. Mirabel, I'm going to go ahead and allow you access into the panelists. Please accept the invitation. And Officer Bradley would be the one presenting this case.
Hi, how are you?
Great.
Hi,
Please raise your right hand.
You need to be sworn.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
And I also see Daniel Brantley. Is he presenting?
Yes, he'll be presenting. Jose Perez had stepped out for a little bit.
Okay. Mr. Brantley, let me know what's happening here. I see that I found the property owner, the condo association, guilty back in May and assessed a $250 fine.
Okay, give me
Tell me, it's really a very simple case. Either they have the business tax receipt or they don't. So that's all I need to know.
okay, just give me 1 second. Let me look over the case. So give me 1 second, Your Honor.
Your Honor, can I please have the floor?
No, not yet, not until I call on you.
Okay.
We can only do one at a time. Everybody can't speak at the same time. Sorry.
I understand.
Magistrate, while we wait on Daniel, this case is in reference to business tax receipt that, the association was supposed to obtain. And being that it's here today clearly indicates that they did not obtain their business tax receipt.
That they did or they didn't?
They did not.
Okay, Mr. Brantley, do you have anything else to add?
Yes, Your Honor. Well, as of the annual housing inspection that Mr. Lopez conducted back on August 3rd of 2022, the condominium did not have a business tax receipt. And as of the reinspection that was done in July, it showed that no business tax receipt was on file.
Who's Mr. Lopez?
I'm sorry, Mr. Perez.
Mr. Perez.
Yeah, I'm sorry, Mr. Perez. My apologies.
Your boss.
Yes, sir.
Okay. All right. Simple question. First of all, Belkis Maribel, tell me who you are, who you represent, and are you aware of the violation notice?
Thank you, Your Majesty. My name is Belkis Mirba. I am aware of the violation. I actually met with you the last hearing. I don't know if you recall, but it wasn't just this violation that we were given. It was a whole slew of violations. It was about a 7-page document. We addressed every violation except this one. The only thing that held us up on which I have that application, it's ready to go. I just came from the city. The issue is that what was holding us up is we had a painter that ran away with the funds and we had to close that permit off. We finally did, but when I went to turn in the application, Christina says that the ID for the president it's not as clear as she wants it to be. So the issue is he's in Israel right now and he arrives on Friday, but at any rate, she told me not to come back until Monday because the city clerk is or the gentleman who works in the front not there.
All right.
And it's not just the it's not just the BTR, it's the BTR and the CU, which we have both applications filled out.
Okay, you're not cited.
And this
as
is a
far as I-
building from 1995.
Yeah, you're not cited here for failing to have a CU. So let's just talk about the business tax receipt, which you probably can't get unless you have a certificate of use, right?
Correct. And that's why the CU is a little bit more intricate than having to get the business tax receipt, which is just one application for the business
What
tax
is the
receipt.
what is the problem with the CU?
Now, the only thing that was holding us up now, one was the permit, and then now the fact that we didn't have his ID clear enough because it's too dark, the one that he sent. So now I'm waiting for him to get back from
Who's in Israel?
the president of the association. Who's the one that signed the CU application. So if not, then we have to go back and have another board member sign and so what, but either way, the gentleman at the front desk where the CU is turned into is not there until Monday. So even if I wanted to do it today, because I was there in person, she said to come back on Monday.
When is the
Christina.
president? When is the president returning?
On Friday.
Okay, so we're going to table this until my next hearing, which is September 7th.
Thank you, Your Majesty. I
Okay?
appreciate it.
All right, we're going to table it until my next hearing. Okay, let's keep
I
going.
appreciate it. Have a great day, everyone.
Thank you.
You too. Item number 42, Lindy and Lily M. Bell, case number CDSP 2022-00010, Shannon Sanders.
All right, Ms. Sanders, I read the file. Apparently there was a fire in the property and it looks like it really needs repairs, corrections. What are you hearing?
Shanna Sanders, Neighborhood Service Inspector. Yes, there was a fire there from the looks of it. This is a case for 60 Northeast 120th Terrace. This was a case that was given to me upon the transition of our code coordinator, who was at that time our code inspector at St. Louis. Some of her old cases were passed on to me to follow up on. So upon looking at the property, I did not observe the fire, but clearly there's sud and things that appears to have been fire damage happening at this property. I followed up with the inspection and sent another letter, a more current letter, saying that the violation that she initially had open was, quite old. I wanted to also, bring it to the property owner's attention that she had a new officer. I did not receive any return phone calls. I have not received any correspondence, had any conversations with anyone from the property. It has been like this for well over a year that I'm aware of. I am showing proper service was given. I posted the property on July 7th with the notice to appear. Certified mailing was also mailed out by the administrative staff. No permits from what I see have been submitted to the city to make any repairs due to the fire damage, to bring the property back up to code. It looks like how it looked today, the day that I did the initial inspection.
It sounds like, and it calls for the building official to consider a demolition order. I saw the pictures. I don't know that the property owner has the wherewithal or the desire to do anything about it. Perhaps the property is for sale. I don't know, but you haven't spoken with anyone about what their plans are?
No, I haven't. Only once when I was happened to be driving by the property, there was a gentleman there. He identified himself as being associated with the property. But you know, I don't know how much associated he was. He could have just been there because the name on file, from the looks of it, was two women, you know, two names of women from what I recall. Yeah, and they're saying Lily and Linda. So again, I don't know what his true association was with it. So I would be comfortable enough to say I don't believe he was the property owner. He could have just been there straggling around. The property has been vacant for some time. Probably thought I was, you know, there to do something, but no one has contacted me other than a gentleman sitting up on the doorstep saying he was associated with it.
All right, I'm gonna enter an order. I'm gonna adjudicate the property owner guilty. I'd like you to bring this to the attention of the building official for possible either demolition, red tag, some kind of order within his jurisdiction. We can't really allow this condition to remain. So bring it for the Unsafe Structures Board or whatever else the building official can do. But in the meantime, based on your testimony and the photographs and evidence presented depicting that the violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Next.
Item number 43, Mount Claire Villas. Case number CEMHS 2022-00485, Christopher Colson.
Mr. Colson,
Yeah, good
new
afternoon.
case, what's happening?
New case, Officer Colson, City of North Miami, Neighborhood Service Department, case number CEMHS 2022-00485 for for a certificate of use. Violation was opened on 7/20/2022. Violation found at that time, no certificate of use on file. Previous re-inspections, still no certificate found, and as of final re-inspection done on 7/26/2023, no certificate of use on file, no contact with anybody from the property either.
Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Thank you, Your Honor.
All right.
Item number 48, O'Dowd's Pier, case number CEFAW 2022-0078, Jannar Murillo.
Murillo, damaged wooden fence. I
Yes, sir.
noticed in the file that you had granted, or the city granted an extension previously because the owner was in Haiti. Have you
Yes,
spoken
several
to the owner
extension was
about it?
granted.
And have you spoken to the owner and what does he say?
No, I haven't spoke to them after I gave them 2 extension I gave them, and after that, I haven't spoke to them. And the fence remains damaged.
Okay, based on the unrebutted testimony of the city's code compliance officer, the photograph and evidence presented depicting that the violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Item number 59. Oh, sorry, 49 through 56. Prestige Cornerstone LLC. Case number for item number 49, CEFOB 2021-00030. Item number 50, case number CEMHS 2021-00112. Item number 51, case number CEMHS 2021-00113. Item number 52, case number CEMHS 2021-00114. Item number 53, case number CEMHS 2021-00115. Item number 54, case number CEMHS 2021-00116. Item number 55, case number CENUS 2021-00525. And item number 56, case number CEZCU 2021-00155. Shanna Sanders will be presenting these cases.
Ms. Sanders, I guess this company, this LLC, won the record because I've never seen so many violations against one entity. Who are they? Who are these people?
You know, yeah, it's Prestige yet again. As you've heard me, I know Christopher has some cases. I think Gennaro had some as well. You know, they've been, from what I recall, they've been a new, I don't want to say a new business, but they've been around that maybe a couple of years. I remember when the name first started popping it up, maybe even a few more, maybe 5 years, 6 years. I remember a gentleman came by the office, identified himself, you know, spoke with our then at that time director. But you know, they're buying up a lot of property in North Miami without the proper permitting, without the proper CUs.
They took over Old King's apartment.
Yeah.
Which one?
The
Old
Kings.
Okay, this is not the group that bought the hospitality school?
That
Old
I'm not
King's school.
sure. I'm not sure. I would have to check and see, but they have quite a few commercial buildings along 6th Avenue. I know they have a couple over on the northeast side. They have another building of mine, 12300 Northeast 4th. They have several, as you see, and this is just the tip of the iceberg of what you've just heard in this hearing. He has quite a few properties that he's purchased.
Well, he is certainly making a point here, and so let's deal with it. Let's deal with 49, the business tax receipt. They don't have a business tax receipt.
Shanna Sanders, Neighborhood Service Inspector. Trying to make sure I see which case that we are for.
00030.
Number 49.
I hear you. Shanna Sanders, City of North Miami Neighborhood Service Inspector. These cases were originally opened by our now code coordinator, Edmi St. Louis, who were then passed to me upon her transition to be our coordinator. So I can't speak of the initial inspection. It was given to me in, I believe it was February of this year, to do a follow-up inspection. At that present time in February, the violations still remained. Business tax receipt and certificate of uses are, you know, quite easy to look in the computer and see. Of course, no applications were on file and still are not on file for a certificate of use in or business tax receipt for this property in or this company.
All right, let's deal with the business tax receipt, case number 49, based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists, that proper notice has been given. I find in favor of the city enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there'll be a daily fine of we'll make it $350 until the violation is abated.
Okay. The next case, Number 50 CEMHS 2021-00112. This is for another minimum housing case for failure. Apply for and obtain a permit to repair and paint the cracked walls. Upon my reinspection of the property, again, this violation was originally opened by our now code coordinator at St. Louis. That was then passed on to me upon, her transitioning to another position. Upon my reinspection, I have reviewed and I see that the property has been painted. However, it has been done without the proper permits. So, per the city's ordinance, all commercial properties must have a paint permit before painting the property. So I'm saying that to say the violation still remains. I am showing that service has been met. I have posted the notice to appear on July 10th, 2023, as well as certified mailing mailed out by our administrative staff. Upon my last reinspection on the 25th of July, the building has been painted. However, the proper permits have not been obtained to do so.
Okay, you need to advise them that repairing and painting the crack walls without a permit is still a violation. So in my ruling, I will specifically note that they're not in compliance because of that fact that they did the work without a permit. So based on the unrebutted testimony of the city's code compliance officer, and by the way, the lack of interest and the failure to show up at these buildings tell me quite a bit. And it's almost a reckless, willful disregard of their obligations to run a legal business. So based on the testimony of the code compliance officer and the evidence presented depicting that the violation still exists, in that there is no showing that the work was done with permits, proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of September 21. In the event of non-compliance, there'll be a daily fine of $500 until the violation is abated.
Next case, CE MHS 2021-00113, which is number 51. This case is for light fixtures that were inoperable that needs to be repaired and replaced with, of course, again, the proper permits. This case was originally opened by our code coordinator at St. Louis in October 4th of 2021, whereas I'm looking at the photos, there were signs of light fixtures that needed to be repaired. They were in disrepair. I inspected the property upon it being passed over to me, as well as over the past few months. The violation still remains in reference to the non-obtaining of the permits. Construction have continued to go on. They have already fully renovated the building. The fixtures have been replaced. However, again, they have not obtained the proper permits for them. I am showing service was given. I posted the property with the notice to appear on July 10th, 2023. Certified mailing was mailed out on July 14th of 2023. On my last reinspection, July 25th. I have had no contact with anyone from the property. And again, compliance has not been met because they have not obtained the necessary permits to replace the light fixtures that were broken.
Based on the unrebutted testimony of the city's code compliance officer, the evidence presented depicting that the cited violation still exists due to lack of permits and that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023. The event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Next case, Shanna Sanders, Neighborhood Service Inspector, number 52, CEM US 2021-00114. This case is for the stairs in or stairway that was in disrepair. Upon looking at the initial inspections that were uploaded to the file on initial opening of the violation being October 4th, 2021, there seemed to be major construction and renovations that were taking place at the property. They were cited and told that they needed to repair the stairways and railings, of course, with the proper permits. It was specifically stated, showing that there were cracks in the initial pictures, and they were instructed to install and equip the stairways with threads and risers. Upon my reinspection of the property, as it was passed on to me, I am showing that the stairs have been replaced. The entire building has been entirely renovated. However, compliance has not been met since the permits have not been obtained. I am showing service was given. I posted a notice to appear on the property July 10th, 2023. Certified mailing was mailed out on July 14th of 2023. My last reinspection on the 25th of July. Violation still remains.
Are the premises occupied or are they vacant?
It is occupied.
Okay. And
Yes.
this is all one property, 12300 Northeast 4th Avenue. How
Yeah,
many-
it's,
Approximately how many units are there?
if I had to count looking at it, I would say maybe 50, 60. It's not
Okay.
very big, but not small either. It's maybe, I don't know, maybe 40, 50. I could quickly look in Dade County records if you want to know the
That's
exact
okay,
number.
that's okay. Are there tenants?
Yes,
This is a tenant, they're not condos.
this is an apartment building.
Okay, gotcha. Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violations still exist because of lack of permits for the work and proper notice having been given, I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023.
Okay.
In the event of non-compliance, there'll be a daily fine of $500 until the violation is abated.
And magistrate is 66 units to be exact.
Okay, yeah, not small.
Mhm. Yeah. Next case, number 53, CE MHS 2021-00115. This case, we have for property address 12300 Northeast 4th Avenue, is for exposed rebars that were observed on the upon initial inspection during the annual housing inspection. Our code coordinator at that time, code officer at St. Louis, observed what was exposed rebars at the property. She cited them, sent out certified mailing to the property owners as well as the listed agents. Upon it being passed over to me in February of this year, I reinspected the property. I am showing that 4 renovations have been made. The rebars have been covered. The entire structure has been resurfaced, repainted, cracks filled, everything of that nature. However, permits have not been obtained to do so. I am showing proper service was given. I post the property with a notice to appear July 10th, 2023. Certified mailing was mailed out July 14th. Upon my reinspection on the 25th of July, again, the violation remains because permits had not been obtained to do the necessary repairs that have been done.
All right, my recommendation, I can't order you to do this, but my recommendation is that the building official needs to be notified that this kind of work is ongoing without permits. And whatever contractor is out there doing work without a permit has to be reported to the appropriate county and state licensing authorities. Because I've never heard of a building this large with people living in it doing this type of work, like exposed rebars, repairing cracks, fixing stairs, doing electrical work. All of these things clearly require permits, and any contractor, electrical, plumbing, structural, that does work in a building of this nature with so many people there without permits is committing a crime. And they need to be held accountable for that. So just my recommendation is that you speak with a building official about that. But based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $1,000 until the violation is abated.
Shanna Sanders, Neighborhood Service Inspector, case number CEMHS 2021-00116. This case, yet again for the record, is for property address 12300 Northeast 4th Avenue. This case is for failure to provide a extermination report to the city upon the initial opening of the violation by our then code officer, now court coordinator, Edme St. Louis, showing she observed, did an annual housing inspection and observed no extermination reports posted, mailed in, submitted to the city. She then cited them. I'm showing that she sent certified mailing out to the property owner as well as the listing agents. Have not received any response from the property upon it being given to me earlier this year. I inspected the property as well as looked in our system. Tried to reach out to a gentleman. I'm not sure of his name. The community planning department gave me a number of a gentleman I don't recall, but I tried to reach out to him to see if I could get some type of compliance for some of these violations. Have not heard back from anyone at all. Upon my last reinspection, no extermination report has been submitted to the city. I am showing proper service was given. I posted a notice to appear at the property July 10th of 2023. Certified mailing was also mailed out to the owners and agents of the property on the 14th of July. Again, compliance has not been met at this current time.
Based on the unrebutted testimony of the city's code compliance officer, the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated.
Next case, CENUS 2021-00525. This one is for, it says, please remediate the mold observed on the door of unit 206, door by a licensed mold specialist, and provide a copy of the final report before the reinspection date. This violation was originally opened October 4th, 2021, where the certified mailing was mailed out to the property owner as well as the listing agents of the property. I am showing no responses have been made from any agents associated with this property upon giving it to me February of this year. I re-inspected the property. I did not observe any mold at the property. However, I went on the complaint that was given to me, and until proof is given to me otherwise showing that that unit has been treated, a report given to me, I felt comfortable enough to leave it open. However, I want to put on the record, I myself did not observe any mold upon my last reinspection. In my initial inspection, I think it was February 22nd of this year. But again, you know, I don't know if we want to, you know, proceed on with this case, you know, however, due to what the initial letter stating provide a remediation report to the city, that has not been met. I am showing proper service was given. I posted the property with the notice to appear on July 10th of 2023. Certified mailing was also mailed out by the administrative staff on the 14th of July. And again, on the 25th of July for our final reinspection, the mold remediation report has not been submitted to the city. However, I did not observe any mold at the property at that time. But again,
do you have a photograph of the door at 206, reflecting the mold conditions, the moldy conditions.
There
And
you
point out to me where you consider there to be mold.
And if we can, and I hate to do this, but I'm gonna let, you know, if you don't mind, Ed and me speak on that, because again, I wasn't the officer at that time. My testimony is that I did not, review any and see any mold, only because again, by now, this entire building has been renovated now in 2023. But I'm assuming at the bottom there, is,
Magistrate, if I may, at the bottom on the door, there was mildew stain. If you look at the crease corner, it was black at the time. And the tenant insists that it was mold. So what I had explained to the tenant as well, in order for me to proceed with this violation, one, she would need also hire a mold inspector, because I am not a certified mold inspector. I can only cite according to our code to request a property owner to go ahead and provide us with a mold report stating that if there was in fact mold. Now, if it is clear by then upon channel inspection, she can proceed with closing the case.
Yeah, I don't know necessarily that they need a full remediation report from a company, which is probably going to cost them a couple of $1,000s. You know, there's either you can see if it's clear, if there's nothing there, then they've complied. But I don't know that we can necessarily require them to do a mold inspection. If there's a question of whether or not there's mold, yeah, but what I'm going to do is I am going to table this particular case until September 21, when we're going to hear the other matters, and encourage the property owner to convince me that, you know, that there is no mold. I mean, it is the city's burden of proof, but again, they failed to show up, so there's no defense. If you tell me there's mold, I have to take your word for it, because there's no defense. But I'd rather be conservative and at this point just wait until we hear the rest of the issues. I don't really see much there that, based on this photograph, that would worry me, especially since is it outside the property or inside the property?
this is an apartment building that's enclosed. It's closed in.
Okay, so you are right. As you take that, this picture was taken from the outside.
This is the hallway. Yes.
Yes.
Okay, so if there's any mold, it is not inside the apartment.
No, it's from the outside on the exterior of the door.
Okay, so that worries me less than if it were inside, because we all know that there's mold in the air everywhere. And if there is a slight amount of mold, it can be very easily remediated with Clorox or some other type of material. I'd rather not have to go through the expense of having a company come out and give you a formal report. So I don't know what to do at this point, other than to just table it and deal with the more serious issues. And then at that time, we can decide whether or not the property owner can verify that there is no mold there anymore.
Okay.
And you guys can go out and, you know, 2 or 3 days before the hearing, you can go out and take a closer picture. I would rather see a closer shot of that corner to see exactly what's there. From this picture, it's hard to tell.
I'll make sure to do that. I've even tried knocking on the door several times to even have a conversation with the tenant to verify, you know, if she feels compliance has been met, or if she's, you know, still wants us to move on. And just as you even asked, I wanted to confirm, even or verify if it was inside the unit, but I'll continue to follow up with it.
Yeah, and usually mold grows where there is humidity, where there is a leak, where there's water. So that's an issue. If you see water leaking from somewhere, or stains of moisture, that would be very telling if there's that. But the city doesn't have anybody, you don't have an environmental person in staff that can go out and take a look at that, can you?
Not that I'm aware of.
Okay. All right. All right, let's move on. Let's put this one aside.
And the last case we have is for the certificate of use, CE ZCU 2021-00155. Again, property address 12300 Northeast 4th Avenue. This case was initially opened on October 4th, 2021, whereas a violation of the ordinance regarding certificate of use was cited, stating that they did not have a certificate of use on file. As of my last reinspection of the property, they still have not yet to obtain nor submit an application for the certificate of use to the city. I am showing proper service was given. I posted the property with the notice to appear on July 10th. Certified mailing was mailed out on the 14th of July. On my last reinspection, no applications has been submitted, nor has the certificate been obtained.
Okay, based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists, proper notice having been given, I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated.
Magistrate, if we can, before I go on, I just want to make sure, if we can, and maybe, you know, Edme can advise me, what did we decide on for that case for 60, the one that with the fire, the one with the fire? And I'm asking only because as we moved on to the next case, our city attorney's office sent me the link showing that indeed there was a fire. I want to err on caution, especially after I'm reading the article and I'm seeing that the mother even passed away in the house due to the fire. I want to see what time frame did we give them and what transpired with that case.
All I remember, I believe the fine was $1,000. I don't know. Can you confirm?
You fined it $500 with the abatement date of September 21.
If we can, I mean, usually I very rarely do this, but especially it seemed like it, listening to the article, it says it saved his grandmother, but his mother died in the fire. So possibly the gentleman that was on the porch could have been there associated with the property, because the article was showing a young man there who again saved his grandmother, but lost his mother in this fire. So I wouldn't mind, and I'm even asking, even though I have not spoke to anyone further at this property, you know, if we can lower that amount some, even if we need to come back and revisit it, you know, later. But I would like to ask for maybe a lower amount. I'll try to speak to the building official. Let's dig a little bit, even if I got to visit the water department and see who's next on file, maybe that we could get in contact with. But let me do a little bit more digging if I can, and let's see what's further could be done with this property before just giving them a hefty fine in a short abatement date.
All right. Just so that you understand where I was coming from, my big issue there was not so much the fine, it's the condition of the property and whether it is safe or unsafe. Is it an unsafe structure? Is it something that is about to collapse? Should there be a red tag? And so I wanted the building official really to give me some insight into what, if anything, can be done to save the house and how much is it going to cost. I believe I said that it's probably not going to be worth saving. And it's probably something that some rich developer may want to buy it, knock it down and build a nice mansion there. But I'm not opposed to lowering the fine. I wish somebody would have been here for the family, and I would have been a lot more comfortable and understanding. But based on your recommendation and what you just told me about the link and the article and what happened, I will lower the fine to $100 And I will then ask that the case be brought back to me on September 7th with the building official present to advise me what else can be done to make that house safe and secure if it can be salvaged.
Okay, and I'll make sure Monday morning I reach out to him upon his return so that we can jump on it and be, have some information for you at the next hearing.
Okay, Edme, are you clear with the ruling? We're lowering the fine to 100. And as far as an abatement date, I think we'll leave it the same. I'd like to hear from the building official first, because if it's something that cannot be saved, that needs to be demolished, then the sooner the better.
All right, magistrate, for the abatement date, you had September 21st. Do you want it to be back for September 7th or November 2nd? November 2nd is your next hearing.
What was my ruling? September 21?
Yes.
Yeah, let's leave it at that, and the building official can take whatever action is necessary in the meantime if it becomes a structural or a dangerous life safety issue.
Noted.
Okay.
Thank you.
All right. Anything else before me this afternoon?
Item number 60 through 62, Tropical Terrace Condominium, case number CEFOB 2022000389. Item number 61, case number MHVIO 2022000597. And item number 62, case number MHVIO 2022000599. Gennaro Murillo will be presenting this case.
Okay. Officer Murillo.
Yes, Your Honor.
The
On
first
September-
one is a business tax receipt.
Yes. So on September 14, 2022, case was opened on the property address 13725 Northeast 6th Avenue to obtain the business tax receipt for Tropical Terrace Condominium Association. I had an inspection on October 11, 2022. There was no compliance. A notice to appear was posted on July 6, 2023. It was also made on July 13, 2023. I had a final inspection on July 20, 2023. There was no compliance.
All right, based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists, that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of September 21. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Item 61.
Yes.
For the same property, 13725 Northeast 6th Avenue. The case was opened on September 14, 2022. This happened when I was conducting an annual housing inspection. They had the fire alarm control panel expire. It was expired on June 24, 2021. When I did the reinspection on October 11, 2022, I didn't have no access to a fire alarm room. The notice to appear was posted on July 6, 2023. It was also made on July 13, and I had a final reinspection on July 20, 2023. And I also didn't have access to the room.
But we have a condo association here.
Yes.
No answer, no response, nothing.
No response. I think this is, I'm sorry, I think this is one owner. The name of the multifamily is Tropical Terrace Condominium, but I think it's only one owner.
For all the units?
Yes, give me 1 second. Let me verify. I'm sorry.
Yeah, because with the alarm panel certification, it looked to me like it.
No, I'm sorry. Yeah, yes. This is a condo. I'm sorry. I was confused. There's a condo. They had a company that managed the property. I know they switched to a new company. But after that, I haven't spoken with the new management.
All right, as to number 61, the alarm issue. Based
Yes.
on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Number 62.
62. Same property, 13725 Northeast 6th Ave. While conducting annual housing inspection on September 14, 2022. A case was opened for the 2 metal hand railings that were loose. They were asked to secure and obtain permit for the building department. I had an inspection on October 11, 2022. There was no compliance. A notice to appear was posted on July 6, 2023. It was also mailed on July 13, 2023. Had a final inspection on July 20, and there was no compliance.
Can you show me, just to refresh my recollection, a picture of the handrails?
One moment.
This is looking down, right? I think there are
Oh.
others.
So you can move the whole railing. So that's why I took like several pictures, like bringing it. That's also needs to be secure.
You recall how many stories?
I think it's like 4. Either 3 or 4.
Okay. What's on the other side of that railing? Are there 2 railings or just 1?
There's 2. There's I don't know. They're 3 floor. So there's one on the north side on the 3rd floor, and on the south side of the 2nd floor.
Okay. All right, I'm ready to rule. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21st, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Item number 64, Yoshi Ortiz and Manuela Gouveia. Case number CVPR 2022-00532, Gennaro Murillo.
Your Honor, this case was opened on May 4, 2022, on the property address 1575 Northeast 127th Street. The case was opened to obtain after the fact building permit for the new driveway that was being done at the property. I had an inspection on June 15, 2022, where there was no compliance. A notice to appear was posted on July 6, 2023. It was also made on July 13, 2023, and some final inspection on July 20, 2023. There's still no compliance.
All right, based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 21, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
And Magistrate, that conclude all the items for today's hearing.
Excellent. So we stand adjourned and we're done with today's meeting.
Give
And
me 1 second, Magistrate.
We got more?
sorry, Magistrate. That was all the items for today's hearing. And
That's
by the
all?
way, yes, I also want to introduce you to our new director, Lazaro.
I can't see anybody. You've got something in front of my screen, so
Wait,
somebody's screen is blocking everybody.
can't see? I'm not sharing screen until now. Stop sharing. Can you see now?
I don't
Stop.
know.